Mr. Chairman. Mr. Chairman,
Yeah.
may I be excused?
Thank you. Please do so.
Judiciary calls.
I understand that you're taking up some of the bills that we sent over to you. Good luck
we
with
are indeed.
They're in perfect condition when we sent them to you.
Thank you.
Do I have a motion? Okay. Any conversation, discussion? All in favor, please signify by saying aye. Any opposed? Bill passes. Do pass. Do we know the macro? Okay. Yeah, tell him I need him. Okay, let me see what we got here. We're gonna, if I can find my agenda here. We're gonna next take up SB 573. Which was a bill that we laid on the table for the purpose of bringing back today. I think the first thing that would be in order would be a motion to take it off the table. All in favor? Any opposed? That's what I'm making the phone call right now for. Let me see if you would. We're going to go to German just for a moment. Wait.
can wait until winter. We can take up.
See, and I don't think you can do that because we're protecting land.
It's easy when you don't travel. Yes, sir.
Good morning. We're going to take up your bills. I like to always take the Senate as soon as we get them in here. I think we'll take your first bill will be Senate Bill 530 dealing with the property liens.
Yes, sir.
Good morning, sir.
Morning, Mr. Chairman. How are you today?
Hope you are.
Appreciate the opportunity. May I begin?
Yes, sir. Please do.
Senate Bill 530 is a bill that is intended to extend lien rights primarily to utility contractors. Currently, under Georgia law, if you're a foundation contractor and you're hired by an owner to build a foundation for a construction project, if you're not paid, you have the ability to lien that property that you're doing work on. And that's been in Georgia law for some time. If, however, you're a utility contractor and you're hired by the owner to perform a certain scope of work that involves putting in, let's say, a fiber optic cable to that new building, and the fiber optic cable will cross not only the property that the owner owns, but also adjacent public right-of-way or perhaps a private easement in an adjoining private piece of property. If you, as that utility contractor, you put in that cable and you're not paid, you do not have the right to lien the owner's property for the work that you did on the adjoining piece of property. What this change in this law says is that utility contractor will have the right to lien the owner's property for the work he does in a public right-of-way or a private easement. And it's based on it's a result of a Georgia Supreme Court case that came out a year or two ago that ruled in a fairly technical sort of way, construing the statute very narrowly because it is in derogation of common law. That's really what Senate Bill 530 is.
Being in derogation of common law, we have to, by statute, explicitly state what under what circumstances liens can be filed addressing property claims.
That's precisely correct. Yes.
Do we have any other questions? Senator Weber presented the bill. Yes, sir.
Senator, I'm trying to understand the situation. My own house, cable there.
Yes.
And cable company runs a line down along the road to my house with the agreement that I'm going to pay for the work that they're doing.
Yes.
And I decide not to pay. I want to file a lien against my house, my property for that. The law says now they can only file a lien against my property for the actual
work that was done on my property, the lien against my property for the amount of the work that was done on my property, not for the 5 miles it took us to get there.
That's exactly.
And you're going to change this so that they can have a lien for the 5 miles worth of work it took to get there.
That's correct.
Okay.
Yes.
And of course, I guess, is it in the situation as I ask for you to do that work?
Yes.
And then I try to back out of it after I get the work done.
That's right. The statute requires that the work be part of the scope of work under the contract between you and the contractor.
Mm-hmm. Okay.
Any other questions? All right, thank you. Yes, ma'am.
You don't mean you, unless you don't mean you can get a lien on the property you want to cross if you have no contract.
No, not that. Just in this case, Representative Fleming's house that he's having built could be liened.
So if you went through my property, you don't get a lien on my property because you own that.
That's correct.
It's mostly dealing, as I understand, with right-of-way work where you have going to the source, so say like a sewer line is on the right-of-way, you've got to bring the line in to the property that will be benefited from that work. All right, thank you. Senator Weber.
Okay.
Anyone else here to speak in support of or in opposition to Senate Bill 530?
Good morning, Mr. Chairman, members of the committee. I'm Barbara Lynn Howell, here on behalf of the Construction Suppliers Association. Just urging the favorable consideration for SB 530.
Thank you, ma'am. Anyone else? Yes, sir. Thank you. Anyone else wish to speak? With the committee, any discussion among the committee regarding Senate Bill 530?
At the appropriate time, Mr. Chairman.
No discussion? Comments? I'll entertain a motion.
Move to pass.
It's been moved to pass on Senate Bill 530. Any discussion on the motion? Any amendments to the bill? Ready to vote on the motion. The motion is due pass. All in favor signify by saying aye. Opposed, like sign. We have favorable passage on this. So we're going to take your other bill up while you're with us, so we can let you get on the business. That's on Senate Bill 569, dealing with local government.
Yes, sir.
Would you please present to us the Senate Bill 569 in this category?
I'll be happy to do that. I want to make sure everybody's looking at the committee substitute, LC 18559OS.
Correct. One in your folder.
Should be in the folder. This bill amends the statutes in Title 36 that deal with procedures and so on, dealing with formation of a new municipality. As you all are well aware, we have a new municipality in the form of Sandy Springs. We also have four others in Fulton County, County North and South. And we have a situation that's developing between Sandy Springs and Fulton County with regard to certain county properties and the right of Sandy Springs to acquire those properties from Fulton County. Specifically, probably the hottest issue is the parks. Sandy Springs is a well-developed area that has a lot of commercial property. There are only a limited number of parks, and the disagreement between Sandy Springs and the county right now is that Sandy Springs would like to take over those parks, and under the doctrine of home rule, Sandy Springs, as a city, can operate the parks, and the county cannot without the city's approval. So it appears that the county is demanding that there be full market value paid to Sandy Springs for the parks. I'm sorry, to the county. Did I misstate that? Okay. The county is asking, and Sandy Springs has said that they think they deserve a tax credit. I shouldn't say tax, a credit against the purchase price for taxes paid over the last 30 years or so for those parks as part of the special service district taxes. And that outlines the problem here. The objective of this bill is to first, when a new municipality is formed, to make sure that the residents in that area, the unincorporated area, deserve and receive a tax credit or a credit for taxes paid over the years in the transfer of county properties, such as parks, police stations, and fire stations, to the new municipality. The second is to assure that the municipality will succeed and have the facilities that they need to operate as a city. And the third is to bring some certainty to the process, because it appears that Sandy Springs and Fulton County may be headed for litigation. So the main thrust of this bill is to set up a procedure where the new municipality, and this would apply to Johns Creek and Milton also, as well as the two cities in South Fulton, first would have the opportunity to negotiate an agreed price. Failing that, they would go to mediation, mandatory mediation before a local Superior Court judge. And failing that, then the Superior Court judge would conduct an evidentiary hearing to determine what the purchase price should be for those types of properties, police stations, fire stations, and parks. That procedure may sound familiar because it is the same procedure or very similar to what currently is in law for the Service Delivery Strategies Act, where cities and counties are required to negotiate and determine the best delivery strategy for services. So we lifted some of those provisions out of that statute and brought it over to this statute to implement that strategy. To bring certainty to the process, what this statute does is it sets forth a formula that the court could use, absent any agreement through mediation or through negotiation. The judge will be empowered to use a formula that first looks at what's called a tax ratio. The tax ratio is calculated by taking the tax digest for the city divided by the tax digest for the county. And it gives you a rough cut. Say that's 10%. So the city of Sandy Springs or the city of Milton might have 10% of the tax digest. There is built into this formula a presumption then that municipality, those unincorporated residents for the last 30 years during the existence of the special district have paid about 10% of the taxes. The second part of the formula looks at what's called an asset ratio. You look at the asset ratio separately for parks, police stations, and fire stations. You calculate a separate ratio, but the ratio is calculated again using what's the original cost paid by the county for the parks in the municipality divided by the county's cost for all parks in the county. And if that ratio, the asset ratio is, say, 8%, that's less than the tax ratio. And the presumption is then that those residents in that unincorporated area have paid for that park once through their taxes. The advantage to this approach is, albeit somewhat of a rough formula, it nevertheless adds a great deal of certainty and can be applied by the judge in a mechanistic sort of way and bring resolution to it and give the city the ability to operate. The same type of formula would be applied both to police stations and fire stations, with one notable exception. In the case of a police station or fire station that might be located in the new municipality, you have to look at the service area for that police station or fire station. If the police station is located in the new municipality but serves an area outside the new municipality, let's say that 60% of the service area is outside the new municipality, the new municipality could purchase the police station by paying 60% of the full fair market value to the county. The logic there being that the county will have to replace that facility to serve that 60% area outside the municipality. I know I'm throwing a lot of facts and figures around, but that's basically how the formula works. And now I believe in this committee substitute we may have, for parks, changed, and Mr. Chairman, maybe you can help with, change the asset formula for parks to determine the asset ratio from looking at county cost to looking at acreage. Is that? Yeah, we did change that. So to determine the asset ratio for parks, you would look at the number of acres of park in the municipality divided by the total number of acres in the county. And that's, again, a rough cut. But we need to make sure that our counties and cities stay out of litigation and that cities have their facilities. So this is, again, a formula that brings certainty to it. There are two other parts of this Senate bill that I need to tell you about. First, one part of it would allow a new municipality to remain in a special fire district in a county that has a separate special fire district, and there are a number of counties. Fire services, fire and rescue, are the types of services that are provided more beneficially, more efficiently on a larger scale, and many cities opt to stay within the county. This just clarifies that they can do that, stay within that special district. The third part of the bill, which is Section 2, has to do with bond proceeds for bonds that have issued for municipal services in a county. If a new municipality forms, they will continue to be obligated, the taxpayers in that municipality will continue to be obligated to pay ad valorem taxes to pay off any bonds that have issued for providing police services, fire services, parks, and so on. We had a bond issue last November in DeKalb County. For the next 25 years, residents of DeKalb will have to pay that ad valorem tax to pay off that bonded indebtedness. In our case, many of you know that I've been promoting the city of Dunwoody. There are funds from the bond proceeds that were earmarked for the unincorporated area of Dunwoody, advertised at the time that the bond was voted on. And so what this provision says is, if the taxpayers have to continue to pay for 25 years, they should get the benefit of the bond proceeds that were earmarked for their area. And it requires the county to spend those earmarked funds in that area, even after incorporation. And that, of course, would apply to other areas. So,
Does that bond funds program specify what is to be program projects applied
yes.
to the bond monies?
Yes, it is a requirement of law that when the county puts forth a bond referendum, they have to publish which projects and what dollar amounts will be funded from the bond proceeds. And what this law says is those earmarked funds would have to be spent in in that area. It was formerly unincorporated.
Any questions?
Does that law that specifies the county shall do that, does that apply to any other binding authority? I don't know the answer to that.
I believe it applies just to the
Fulton County is getting ready to do a public safety facilities authority, I'm told, and for $50 million. Are they required in that?
I believe
you just quoted to specify their project. And does this bill have anything to do with that new authority that you're?
it wasn't my specific intent. I would ask you to look at the bottom of page 5. There may be some language there that may give us some guidance. Subsection D1 there, which is existing law. This is the definition of a statement of intention, where it in the context here, it speaks of a county, municipality, or other political subdivision.
So I assume that would be some creation of some entity, bond authority.
What you're
It could.
talking about is under that, I call it the Public Defense or Homeland Security Authority. The county can set up a $50 million authority. The district would be the county boundaries. The purpose
Yes.
of it would be for their specified need. In this case, is the jail situation, which we're still working through.
I would,
It would affect, obviously would affect your Sandy Springs as well.
yes, the language that we've added on page 6, if you look at that, I believe that that's limited to just dealing with counties and municipalities. So I don't think it would affect the authority that you're speaking of. That's my initial reaction to that.
I may have one other question.
Yes, ma'am. Please.
You can find, you got quickly through this formula you suggest that you're going to give to the Superior Court. Where exactly is that? Is that, must the judge accept that formula, or is that simply a discretionary formula?
The formula is set out in page 4. At the top of page 4, line 3, is paragraph 3 there. This is the third step. If you fail negotiation, if you fail mandatory mediation, if no, the judge shall determine. And
So it's a mandatory formula.
that's correct.
If you like your formula or didn't like your numbers, he or she will be.
Well, I think the factual hearing will determine issues that may be unresolved between the county and the city as to what, quote, may be the purchase price, what may be the division, the digest, other questions regarding acreage, say, of the parks in the county and for the city.
Yeah.
So if there's a dispute about that, then the judge will have need to hold a hearing to resolve those issues by conducting a factual hearing.
I agree with all that. That makes sense to me.
Yes.
What I'm trying to decide, what I'm thinking of asking myself, is whether or not you could tell the judge that there's only one way he or she may determine these numbers to go. And that's what I.
We looked at various approaches. I had a number of, over the last 2 or 3 months, a number of different approaches drafted with the assistance of legislative counsel. If you were to say, as we did early, that a new municipality should be given a credit for taxes paid over the last 30 years, so long as the special district's been in effect, that I think is an invitation to protracted litigation. And I think that could be very cumbersome for a court to try to determine. And these new municipalities need to have some certainty going forward as to what facilities they will or will not have available, and what the purchase price, within a certain range of certainty, what that might be. And as the chairman pointed out, there will be some fact questions that need to be answered if it gets to this stage by the judge. He'll have to look at the appraised value of the tax digest. He'll have to look at the acreage, have to look at the original cost, and make some factual determinations. If there are other disputes that arise out of this statute, then the judge also obviously would address those. But the formula is intended to give some fairly mechanistic guidance to the judge so he or she can look at it and have some certainty as to how to proceed.
Thank you. Any other questions? over here.
I believe Representative Bruce was first, Mr. Chairman, then on.
I would say I have interest in this. Parks and other things, purchase, someone purchased early on.
Yes.
And I was trying to make sure the value obviously is different than it was at the time of purchase.
Yes.
Does your formula account for that?
3% per annum on the land and any improvements to the land.
And the second question, obviously because everybody in the county helped pay for those properties.
Yes.
And I'm more talking about parks than
Mm-hmm.
anything else right now. And the parks were available for use by anybody in the county. Is there any intent for the surcharge or some sort of non-residents of the municipality using those parks at some point in time? Is there any intent on surcharge on those big municipalities?
That's an excellent question, Representative Bruce. I know that the chairman and I spoke yesterday about adding a provision that would prohibit any sort of a surcharge being charged by the municipality.
Fine. Look at page 5, President Bruce, at line 23, that is language is added dealing with that very thing. So that there will not be an increased user fee for someone who's outside the city for those parks. Line 23, section I, on page 5. Next question. Ms. Lindsay.
Just want to, for clarification purposes, when it comes to a park, let's start with the park. Are parks paid for by the county out of the special district funds or out of the general fund?
I think it could be either.
Yeah.
Historically, and recognizing that as a possibility, I think that this somewhat mechanistic formula nevertheless recognizes that by looking broadly at the tax digest. Mm-hmm. So that if it were paid out of general revenues or special district revenues, nevertheless, you're looking at the city digest divided by the county digest. So the city may have paid for 10% of the general revenues over the years, presumptively, or special district taxes. Does it make sense to you?
A little bit. Because obviously my biggest concern is that, funds paid out of the general fund, that gets taken from everybody countywide, and parks aren't necessarily evenly distributed throughout the county, and sometimes you've got one area who in the past out of the general fund paid for a park in a newly incorporated area. For instance, I live inside the city of Atlanta, and we pay money into the general fund. I just want to make sure that my folks aren't paying for the parks in a newly incorporated city.
I guess we could do on the formula that was paid for Chastain as a way of doing it.
Yeah. I don't know. I'm trying to think it through.
Chastain was given to the city, by the way, by Fulton County.
Well, we appreciated that about 40 years ago.
I think one of the challenges is that there's going to be so many different variations, points that could be made, that we tried to arrive at a formula that, again, would add some certainty and resolution.
Okay.
Representative Stevenson.
Thank you, Mr. Chair. I have a couple of questions. First, thank you, Senator Weber, Section 2.
Yes.
I like, of course, because this applies to all counties, and I'm from Tab, as you well know.
Yes.
This is near and dear to me. On page 3, I'm sorry, on lines 8 through 18, you talk about paying into an estimated purchase price into escrow. How is that determined absent the formula?
Well, I'll say to you that, in all honesty, this committee substitute was drafted with a few changes. Representative Willard.
We were looking at the concern that I had in my mind from a constitutional standpoint. There's going to be a requirement that the county make the transfer of the property without a resolution of what may be the purchase price if they've gone through the negotiations and it's still in dispute. So what we're doing here is saying, city, you will be paying into what is the anticipated amount based upon that formula as seen, much as we do with what we call a quick take in condemnation. So there is a payment made into the registry of the court, and the county then to have the ability to draw it down without jeopardizing its position. But it would still continue on with the battle regarding what the concerns may be about the formula, what should be applied to it, and how it's to be ultimately decided for purchase price.
Now, the final determination of the purchase price means to me that is once it reaches that portion with the judge. So you're saying that throughout the mediation period, you do not have to have a final determination?
This will only occur when there's a transfer of the property, which I believe in this situation is after the initial negotiations, as I recall, between the county and the city, and that has failed. Then there's going to be an action in court in which the city will make the payment, and that starts the mediation process.
Now, I'm trying to understand the mechanism, how it works as a practical matter, because it has deadlines on within 30 days. Certain things have to happen. How much time are the parties given to negotiate prior to any filing in the court? Is there any time?
Let me ask something right quick. Where's Josh? Would you ask the people outside the door to please move away from the door? That the talking is disturbing the conduct of the committee. Sorry, go ahead. What was your question again, Ms. Stevenson?
The question is there any time deadline, sort of a time to exhaust, if you will, the administrative remedies prior to seeking judicial relief?
Let me go through what I think the timetable is. You have the city make the notice to the county, give the notice to the county they wish to acquire the properties.
Yes.
That notice then triggers a 60-day negotiation time between the city and the county.
Okay.
Yes.
That's what I was looking for.
Yeah,
where's that 60 day? I see on page 2, starting line 22 to the 30 day. Where is the 60 day period? Is that on page 3, starting at the line? No, I see the mediation.
That's mediation.
If you go to page 2, line 12 through 21, this describes the process where a municipal corporation would adopt a resolution stating their intent to purchase certain properties. And then in the last sentence on lines 19 through 21 contemplates that notice of that resolution has to be given at least 3 months prior to the date that the municipality is removed from the district, the special district. So that starts the process whereby the parties have the opportunity then to negotiate an agreed price. Now, conceivably, either party could demand mediation prior to the expiration of that 3 months, but that's not the intent here. We could make it express that they could not. But failing negotiation, I think then they go to mediation.
Yeah, I think also look on page 2, line 31, dealing with it says such notice shall be provided with respect to each such property no less than 2 months prior to the date the qualified municipality intends to assume responsibility for providing those services using the property. So I think that was where I was using 60 days as time that will be open before you have the action being filed in court. It doesn't say negotiation, but yes, that's what the intent of it is, to resolve those issues during that 2 month time.
And then, Mr. Chairman, ask one more question.
Sure.
Relating to the bad faith on the mediation,
Yes.
as well as court costs, that's on page 5. Lines 19 through 20. Are there any criteria, because my understanding is the mediation is borne by both parties. And then, after that, the judge will make a decision based on a formula that you've already set forth. So I really don't know how that part would be in bad faith, but what would be bad faith in terms of the mediation?
Well, that obviously is something that the judge would decide. That provision that you're referencing on page 5 is the same as what you would find in the Service Delivery Strategies Act, allowing the judge to find bad faith. In thinking whether we should include that here in Senate Bill 569, I determined that perhaps it would be good to have it in there just so the parties would realize that if they don't act in good faith through the mediation process, there could be a consequence down the road. So I think that sends a bit of a message to the parties that they need to try to mediate in good faith. And that's why I left it in there.
Okay. Mr. Chairman,
yes, ma'am.
Is it the way this bill would act that at the end of the day, if mediation doesn't work and it has to be enforced by a visiting or senior judge, it will be enforced pursuant to this formula?
Correct.
Okay. Thank you.
The factual issues may go in to determine the amounts to be used under the formula, but the formula would be the court's direction.
And the factual issues are a function of the mathematical
Correct.
assessment, and the mathematical assessment are the factual portions.
Yes.
Well stated. Representative O'Neill.
Two quick questions, maybe, or not so quick, and I might be ahead of them on page 6. I'm looking at line 16, paragraph B there. I'm trying to be a good detective and follow the money. But maybe you could paint me a real-life example of what we're trying to say there. Let's assume that this new municipality wants to buy a fire station.
Yes.
So it was built by a bond proceed, or is in some process of that. How does this language relate to that?
If I may, I can give you an actual real-life example.
Okay.
As you know, in the proposed city of Dunwoody, we have a park that's called Brook Run. It used to be a mental retardation facility owned by the state.
Who's we?
The county of DeKalb owns Brook Run, purchased from the state for about $3.7 million 8 years ago. The park has not had a lot of capital investment. As part of the bond referendum last November in DeKalb for parks, about $100 million in proceeds and bond proceeds. $11 million was earmarked for Brook Run for capital improvements to start working on the master plan for that park. Those bond proceeds are earmarked for that park, and if Dunwoody were to incorporate under this provision, that $11 million would continue to be earmarked for that park. And if Dunwoody were to purchase that park from the county, then the county would be required to pay the $11 million to the city, and the city would be required to use that money for that purpose.
Well, I guess maybe that's where I'm having confusion. You got a park that's worth $3 million, that's got $11 million coming to it. That's 14 or something like that. How is that going to work into the formula of value for determining what the city of Dunwoody is going to need to pay DeKalb County for that park? If it knows that it's going to be approved by $11 million in bonds, how does this work? Tell me how that money will work.
Section 2 of this Senate Bill 569 has no direct relationship with the formula that we've been talking about in Section 1. Section 1, which deals with the transfer of the parks, looks historically at what was paid for the park and what the tax digest is of the proposed city versus the county in that formula. So the short answer is to say the $11 million in bond proceeds to be spent in the future is not taken into account in the purchase of the park.
Let me just say, Section 2 deals with an outstanding bond issue that may be, let's say, specifically addressing the circumstances of DeKalb County if there becomes an incorporation of the Dunwoody area. but it doesn't, to our knowledge, apply, except it is general law. If there were a municipality where there's an outstanding unspent bond fund, there would be this language to help guide the county and that new municipality what's to be done with those bond funds, programs directed within the boundaries of that new city.
I've got one other question before we move on, and with all due respect, I would suggest to you that since this is a general bill, and I know it's aimed at Dunwoody, we've got about 17 new cities coming to Fulton County. I'm not being a little facetious, but there's very important that this is inevitably going to apply to. And the accounting for all this, I think, is going to be huge, so we don't get cities and counties in civil wars. This doesn't impose an obligation to take title to these amenities either, but it's just the option.
It's the option, that's correct. And this bill was drafted in cooperation with state representatives and senators from primarily Fulton County, because it will affect all those new cities in Fulton County.
Last question, just in a general sense, on the last page, page 7,
yes.
line 6. I've never seen anything decided by a 1/3 vote. Could you tell me the logic of 1/3?
I will say to you that language should have been taken out. That was language suggested by Legislative Council some 2 months ago, and I noticed in the earlier version that it was still in there, contrary to what my intent was, and I see now that it's still in there. So it doesn't make a lot of sense to me either, to be honest with you. So I'd certainly be open to amending Senate Bill 569 to take out some of that language, Mr. Chairman. If
Why don't you consider what you want maybe used there in lieu of the 1/3? We have some other questions over here, Ms. Oliver and then Mr. Bruce.
There's clearly going to be some other bonding authorities beyond this gas parks bond from last March. We're going to be creating, soon, so that makes me nervous. But just back as a pure policy now.
Yes.
Conceptually, having a procedure and having the judge determine value and having a timetable so there isn't open-ended, unresolved negotiation makes a lot of sense to me. But I can't, as a policy decision, convince myself yet that giving the judge one formula is a good policy, as opposed to giving the judge, you may use this formula, if you use another formula, it has to be commensurate with some value. That's where I was stuck a little bit, because so justify for me giving the judge as a policy now one formula to use as opposed to this formula or this.
One approach that you could use, and an attempt was made to do this, was to say to the judge, here's a list of factors for you to consider in determining the purchase price to be paid by the city to the county. Some of the factors you might list is what is the fair market value of the park? Was the park, what was the original cost of the park? What sort of improvements are on the park? How much has been paid in taxes over the years, in special district taxes, by the taxpayers in the unincorporated area? How much was paid in general revenue taxes over the years? And how much of the money how much did the county draw from both general revenues and special district to pay for those parks or the police stations? And then you need to look at how long has the county owned the park. Have they owned it for 100 years or for 2 years? And if you do that, I think, and you say to the judge, determine a purchase price, I don't think it really gives the judge enough guidance as to what he's supposed to determine.
But let me make another argument. Let's assume that doesn't give him or her enough guidance. Doesn't give them a specific formula take away the advantage of mediation and folks reaching a arm's length negotiation? What you really want is for them to reach an agreement. If you give the judge a specific formula, doesn't that take away their incentives to reach an agreement for the time?
I would respectfully submit that it provides incentive for the parties to come together and reach an agreement. The objectives here, again, are to provide certainty to the process and to avoid litigation. And from the city's perspective, if you're trying to form a new city, or even if you're an existing city, you need to know whether that 100 acres in a highly developed commercial area, you're going to have to pay fair market value or something less. Because if you've got to pay $40 million for a green space for a park, fair market value, that a judge might find without guidance, that is cost prohibitive for a new city.
You've got, I'm sorry.
I'm sorry.
Obviously, you also have a prohibition in Fulton County. I don't know if there's in other counties, but prohibition, the county cannot operate parks inside the city. And so what we're left with is a standoff if we don't have something there of the certainty that Senator Weber is speaking of. How do we finally get this property over, or does the county say, hey, we don't have to sell it to you, we're just going to turn it into a private development and take away the park from the people who over the years have paid for that park and deserve to continue using it, whether it be north or south? Yes, ma'am.
Thank
Ms.
you,
Stevenson.
Chair. Representative Oliver pointed out what my first question, because if there's a quantitative formula at the end of the day, depending on which party is advantaged, I don't even see why you would even go to mediation, because the end result is a quantitative formula. Second, if the intent of the bill was to apply to the cities of Fulton, then is there not a way to limit this to Fulton County?
Well, keep in mind that this Senate Bill 569 at the start applies only to those cities that are formed in counties that have special districts, special tax districts.
I understand that.
And for instance, for police, there are only 12 counties in the state of Georgia that provide police services.
But you said there's only one county that asked you to bring this bill.
Well, this bill was drafted as a result of a joint desire on the part of a number of senators in Fulton County and myself in DeKalb County to try to address this issue. And speaking with the Sandy Springs representatives, they also wanted to have some certainty because, as the chairman explained, there's a stalemate that's developing between Sandy Springs and Fulton County. Sandy Springs has the power of zoning, and if Fulton were to try to use the parks to sell to a private developer, then they would have to get zoning approval from the city for that.
One more question, Mr. Chair. Who determines the math for the judge?
Who determines the math?
Under the formula for the judge. Who brings that information?
Well, I would assume that the parties to the lawsuit would present their calculations, and the judge would make his own determination. Based
on the two different math, they will look at who applies the formula and what facts they put in, determine whose formula is correct?
Yes, the judge will have to make a factual determination as to what is the appraised value of the tax digest, what is the original cost paid by the county, what is the acreage of the parks, a number of issues like that. And there may be disagreement between the county and the city on some of those issues, and it's the judge's obligation then to try to resolve those factual issues.
Thank you.
Yes.
Yes, sir. Mr. Cumlin.
Sir, I like just one what if question.
Okay.
I'd like to take it back in and what's the general bill, but you had a situation, I'd like to be able to say to a fire department, a fire station.
Yes.
If they're right on the line, but for that happening, the municipality or the county one might have to build a brand new one to service an area by law or regulation.
Yes.
They'd have to rebuild it, build it at fair market value, but yet selling it on, the formula which would be on historical costs. I have a little equity problem there.
There is a, may I? There is a provision in here to deal with that situation, which I know you walked in a little bit after we got started. In the event that the fire station, to use your example, is located in the new city, but it serves an area outside the city. If that area, the service area is 60% outside the city, then the city has to pay to the county 60% of the fair market value of that facility. The presumption is that the city has paid for 40% of it, but there's also a principle that the county is going to have to replace that facility at fair market value to serve that 60%. Again, it's a formula that brings some certainty to it and tries to bring some equity along the lines that you figured out, I think. So it's a good question.
You got anything further?
Yeah, just
Mr.
a question as whether or not you explored this possibility or not. Simply requiring that if any of these facilities lay within a newly municipalized area, simply requiring that the county lease these to the new city and for the city to maintain them. But whenever they get abandoned, then the county gets the benefit of the bargain of the sale. But allow the cities to continue them as long as they wish to continue using them for the same purposes they were using before.
Well, that's always an option for the parties to agree to if they wish to negotiate to that point. In the case of a number of new cities that are forming, I think that they would want to take over ownership from the county so they could perhaps do whatever they want with the property instead of having to worry about a reversionary interest going back to the county someday.
And that continue uncertainty down the road.
I understand. I'm just trying to think.
If the county makes a decision, we're going to turn this to a private development, then they offer it. The city's supposed to zone the property, but the city's going to be also restricted by the constitutional requirements of highest and best use as to someone coming in seeking the zoning of it. So that's again part of that uncertainty as the future rolls on, and you got what is really public need property that needs to be continued to that purpose. Any further questions of the presenter, Mr. Bruce?
This has got to be one of the most difficult bills for me because of the tactical requirements.
Yes, sir.
The south side. But at the same time, as an applicant, what's going to drive me nuts is the notion of taking the property and forcing the local government to do something that they may not want to do with property. I do have a question about the property that is not paid for. It's not completely paid for yet. This may come up with some finance about the roof. How is that handled in the event that the piece of property that we're talking about is not yet fully paid for? And who ends up paying for it, I guess? There's an agreement made between the two parties or whatever to build a building, to buy the land, or whatever it is. If that is not fully settled, and now this new city comes along and says, okay, we want this property, we want to build, we want whatever. How is set the formula? If that formula doesn't rise up to cover the property debt, so to speak, what happens?
I think what you're asking.
Go ahead.
I think what you're asking is if the county has purchased a piece of property but still has debt on the property. Well, in that situation, I would think that the amount that the county purchased it for would be considered the original cost, and that would work into the formula.
All right. Thank you a minute. Let me suspend at this moment. We have also with us, want to recognize today, Mayor Eva Galambos from Sandy Springs, and I know you've got another appointment facing you. Would you care to address the bill? Come forward.
Mayor, how are you?
Good morning. Thank you, Mr. Chairman and members of the committee. Sandy Springs is very interested in this bill because we have faced an untenable situation since we became a city in December. Everything is going along very well, but we have this limbo situation where we're now operating the parks, and we're doing all the maintenance, and we're running a full program for children and adults, and we read in the paper that the county is considering getting an appraisal of current market value for these parks to put them on the market and sell them. So there's just nothing in state law that gave us a process of dealing with this situation. And of course, as we grew into cityhood, we realized that state law was pretty silent on a lot of points that deal with new municipalities. And this is a serious gaping hole of how you handle transfers of properties. The same thing is true now of the fire stations. But the biggest problem has been with the parks. And incidentally, here we are with the county talking about getting appraised values of parks that were acquired by the county as a gift from what was Western Electric, and then the facilities on the park have been built with user fees. So, it seems a little strange to talk about putting that on the market now. So we are very, very interested in this bill, and we think it would put a process in place so that we could deal in a rational manner and move ahead. Thank you.
Any questions of Mayor Galambos? We're glad to have you with us today, Mayor. Thanks for coming in. Anyone else wishes to speak in support of Senate Bill 573? I'm sorry. We have the wrong number. 569. Anyone else wish to speak in favor of it? Anyone? Yes, ma'am.
Susan Pruitt, Georgia Municipal Association, and I'll speak in favor of it simply to put in a process for resolving these, and that's what I would commend to you, is that there be a process so this does not go on indefinitely, and to avoid litigation between cities and counties. That's never good for the taxpayers, ever, to be funding both sides of litigation. So there will be new cities in Fulton coming online, and this is going to be an issue they're going to face as well. So I would encourage you to put in a process that gets the parties to a resolution in a timely fashion, an equitable resolution for everyone.
Thank you. Yes, ma'am, Ms. Oliver.
Do you have an opinion about whether or not the process must include a specific formula for the judge to consider, or should the judge be given greater latitude? We don't have a position on that. We simply believe that it is critical for there to be a process that leads to some finality and that is equitable, because the residents of the city are also residents of the county. In this instance, they've been paying special district fees, which have gone to some of these specific amenities. And so we do want to make sure that those citizens are not overburdened as their new cities start to form.
Any further questions of the witness? Anyone else wish to speak in support of the Senate Bill 569? Anyone wish to speak in opposition? Ms. Hutchins.
I think you guessed, Mr. Chairman. Good morning, Mr. Chairman and members of the committee. I'm Diane Hutchins, Executive Director of Intergovernmental Affairs for Fulton County. Since I have not had a chance to read this committee substitute, I cannot speak to the specificities of the bill. I have heard what Senator Weber has outlined, but in general, the Board of Commissioners voted last Wednesday by a vote of 501 to oppose this bill. The rationale was that they did not think it was appropriate for the General Assembly to dictate how county-owned property was disseminated, that should be something that should be dealt with between the city and the county. The only specific point I'd like to get to would be something that Representative Lindsay referenced about the possibility of leasing these items. As I said, I have not seen the committee substitute, but from the version that I have, essentially the municipality dictates how this process goes by making its determination as to whether or not it wishes to purchase. Once it makes that determination and passes a resolution to do so, all bets are off. There would be no possibility to lease. So the Board of Commissioners would ask you to give this a do not pass recommendation, and I thank you.
Any questions of Ms. Hutchins? Let me ask one. Has the county been in the discussion process of getting appraisals of the park properties with the thought in mind of potentially selling those to third parties up in Sandy Springs?
Mr. Chairman, I have absolutely no information about that whatsoever.
Okay.
I'm sorry.
Thank you. Any other?
Question on what you just asked.
Yes, sir.
Is that the thought that these properties would be sold to third parties, even the buildings? You know, somebody, I was watching TV last night, somebody bought a school and turned it into a house, but they live in the school.
That's surplus property.
Yeah. I mean, so is that, I'm trying to figure out what's driving all of this. You know, I'm hearing, you know, that you were trying to do a city out from Cobb County, and now all of a sudden it's becoming an issue for Fulton County. I'm just trying to understand what is okay. And I think Chairman over there was kind of deep involved with the money to see where people are going. And I'm not sure I see where it's going to go either.
Let me, okay, Mr. Fleming.
I follow this somewhat closely, but I'm no expert on Atlanta and Fulton County problems. But I know Fulton County is a little strapped right now, cash, and looking for some money. And if we don't pass something like this, it would be possible for Fulton County to sell a park and someone put a building up there. And that's, man, I know you can't sit here and speak for the Board of Commissioners what they may or may not do. But if you got a multi-million-dollar property up there in any city, South Fulton, or whether it be North Fulton, I mean, unless we put a process in place, what's to stop that from happening?
I think we're talking about discussion among the, is that a question to Ms. Hutchins? Or?
She may have an answer why that
All right.
not going to happen for that.
I think Representative Fleming, one of the answers has already been given, and that is the fact that particularly in the case of Sandy Springs, and it's anticipated that would also be true for cities of Milton and Johns Creek, and ostensibly for the city of South Fulton and Chattahoochee Hill Country. They have taken over, Sandy Springs specifically, immediately took over, as quickly as the law allowed, its zoning process. There's nothing right now, ostensibly, that would stop the county from selling the property. However, as Mayor Golumbos, I believe, said, and as the chairman said, the zoning issue takes care of that because the city would have to be ready to zone it. So I think at that point there may be an impasse. You might be able to sell it, but the question becomes, for what use could you put it absent the city's agreement? So I think that's the answer to the question.
Mr. O'Neill.
Mr. Chairman, just not really even tongue-in-cheek. If this was private property, there would be powers of eminent domain available to government. Is there no such power available to the cities over the county?
I think that's limited as to the ability for a city to condemn another public entity's property as long as it has use of it, and then if it declared a non-use of it, then potentially perhaps it could be a condemnation of it. Then you're still in court battling about values. That's the last issue there. The concern, frankly, is, and I've had comments I read in the paper about desire of some commissioners to seek a sale of these properties potentially by getting appraised value and then finding a developer that wants to pay those dollars for it, which are properties really acquired either by gift or by purchase with taxpayers' monies. And I sit here as city attorney, sort of in a dual role, frankly, city attorney of city of Sandy Springs, because I know some of the background as far as acquisition is, and what we're talking about in this bill is just putting something in as a mechanism, as a formula to resolve this point so that the use continues as a public use. It is in jeopardy. It is in jeopardy.
Doesn't it constitute a taking on behalf of the city?
It is not a confiscation because there's a value to be paid, and the value has to be paid at the time, the trigger mechanism, the 2 months. Yeah, I know. There's not a taking, there's payment to be made. The bill calls for payment to be made under that formula. The question is the policy of the state through the action of the General Assembly in saying this is something that should be done or in place as a way of resolving a dispute between two governments over transferring of these properties. Because I say in Fulton County there's not even a use Fulton County cannot even continue operation of the parks based upon restrictions in the law. So there has to be a leasing, but again, the leasing is there's no certainty how long that can go on. And the law we did last year set up a transition time, and it only compels the county, in this case, to provide the use of these parks to the city during the period of transition. When that comes to an end, all bets are off. We're back to where we were, and the risk is extreme.
Isn't it compelling them, excuse me, Mr. Chairman?
Yes, sir.
Isn't it compelling them to sell the property?
This bill would say there will, if there's an option election by the municipality to acquire the property, there will be a transfer of title or sale of the property based upon the formula within the bill establishing how that value will be arrived.
I guess what I'm trying to distinguish, because of the overall policy of not the Fulton County, Fulton County's business is theirs, and I don't want to try to
Yes,
interrupt it. I'm certain that's way bigger than me. But really, aren't we codifying city condemnation in a sense? It's
City
setting a formula
condemnation.
for buying property.
I think what Senator Webb pointed out is between two governments we have similar things dealing with like the strategic service agreements. We have also the local option sales tax. All these things call for there to be a negotiation between the parties, and if there's not a resolution of that between the parties, there is by statute a fallback provision, many times a formula that will be used to apply a resolution of those issues between the two governments. Between two governments.
For that statute.
Yes, sir. And that's what Senator Weber earlier was saying. We have followed within this bill a lot of the language from the strategic service agreements as to what and how those things happen. To set up this mechanism of negotiation, mediation, finally, if you can't get it resolved, it has to go to court to get it resolved. That's what we've done. It's part of it. Any further discussion? Thank you, Ms. Hutchins.
Thank you, Mr. Chairman, members of the committee.
It's in the rest of the committee. Discussion among the committee members. Anybody have a committee discussion? Ready to entertain a motion?
There was a change, I think.
Yes, we'll get a motion one way or other, then we'll talk about changes. Move to pass. Moved and seconded. And do we have any amendments to propose to the bill? Yes, ma'am. Ms. Oliver? Two amendments. All right. State the first and give us the page and line reference.
Page 7, beginning on line 6. After the word unnecessary, put a period and delete the language without a concurrent declaration by 1/3 vote of the governing body of such newly formed municipality. And I'd like to ask a question of the author about that.
Yes, ma'am. Please do.
What is the necessity of lines 3 through 6 of that paragraph? I understand finding the release of the proposal.
Thank you for your question. It's a good question. We're dealing with Section 2 here, which again deals with the relationship between the county and a new municipality and the bonded indebtedness funds from which have been earmarked for that city. So I'll use the Brook Run example again, since I'm most familiar with that. The citizens of the unincorporated area of Dunwoody, if they incorporate, would continue to pay for 25 years on those bonds. So the rationale is that $11 million that's earmarked for Brook Run should be spent there. Under the current law, the county currently has the ability, with a supermajority vote, 2/3, to declare that $11 million project unnecessary. This language on page 7 that you reference is an attempt to prohibit the county from doing that.
Prohibit, even if it may be good policy.
Yes.
Even if it may be good policy to sell a piece of property to a developer with the idea of using the money buying the property, you're saying that they can never.
In the event that that area were to incorporate, then those funds should be spent there, because the relationship between the county and the proposed municipality or the new municipality is oftentimes strained, and it's an attempt to keep the status quo in place and not to allow any actions that would prejudice the taxpayers in the new municipality as a result of incorporating.
Mr. Chairman,
Yes, ma'am.
may I, parliamentary inquiry, may I withdraw my amendment and make another?
The amendment has not been voted on, so you can withdraw it.
Ron, I'd like to make a movement that all paragraph B, lines 3 through 7.
Page 7. The amendment, motion is to, by amendment, delete paragraph B beginning on page, line 3, correct? Any discussion on the amendment?
Mr. Chairman, can I ask you to solve this question?
Yes, sir.
I'm trying to understand what you're getting, and I think I do. Let me give you an example. You got a new city that's going to move park there. I think you and I both would agree that that needs to probably remain a park unless the city decides, the new government, for whatever reason, they need to use it for something else. And my understanding of this paragraph was to keep the county from selling that before the city had a chance to do what they wanted to with it. I mean, maybe I missed something in the explanation.
Would you like for me to try to explain it?
Yes, sir.
Okay.
Is that the way you understood it, Representative
Okay.
Oliver?
I understood it that in no circumstances could the county make that determination. And I don't think that I want to tell the county that they can never make that determination. I don't think.
How about with the concurrence of the local municipality?
If
Now-
that were true, then I would.
Now, all we got to do is strike out by 1/3 vote on line 6 to do that. It says, shall not do it, declared unnecessary without a concurrent declaration of the governing body of such newly formed municipality.
So I'm going to make a third one.
That's what we're trying to accomplish here.
Thank you.
Okay.
So I'll make a third amendment. I withdraw my first two. It's my third attempt. On page 6, page 7, line 6,
Yes.
I'd like to eliminate by 1/3 vote.
All right.
And so it shall read without a concurrent declaration of the governing body.
Thank you. Any discussion on the motion? Motion to amend. All in favor of Representative Oliver's motion to strike by 1/3 vote on line 6, page 7, signify by saying aye.
Aye.
Opposed, like sign. Motion. Second amendment you have. All right. What is that?
Page 4, line 7. I'd like shall read may, and I'd like to add the following language at the end as follows, and shall make specific findings of fact relative to said factors. The judge may determine the purchase price as follows, and shall make specific findings of fact relative to said factors.
Okay, the only concern I have there, the judge so often says, what am I supposed to do when the state General Assembly can't give me specific directions to how to do it. That's what we're going to have running into. Because you ask the judge to do something in his wisdom that we're not able as a policy to say for the court, here's how to follow it.
Can I get you to repeat that?
Yes, sir. Repeat the amendment. You want to repeat your amendment?
Delete the word shall on line 7, page 4, and insert may, and then before the semicolon, follows, add the following language, and shall make specific findings of fact relative to said factors. So that the sentence shall read, the judge may determine the purchase price as follows, and shall make specific findings of fact relative to said factors. I'm happy for any improvements upon that. My intent is to give the judge a formula that he or she may use and require he or she to make specific findings.
Yes, sir, Mr. Fleming.
Once again, Ms. Oliver, trying to understand your amendment, and I'm sympathetic to your idea that we give them some flexibility in there. That's not my problem. But if you change that shall to may, do you then give the judge the ability to not make any decision on what the value of the property is?
I don't think that you anymore give a decision to not make a decision on the value, then you give the judge a decision to not make a decision as to custody, or not make a decision as to.
Is it possible to go back and say, okay, you city, county, y'all go over that, and you come up with a resolution, or I'm not going to decide for you?
Well, that's what a judge does, not know.
Yeah.
Like in divorce cases.
And my point is this,
What
do
is
we
this?
want that to happen? Do we want the resolution not to come to a head?
I want the process and the time, and I think that's a very good step. And I want there to be a Superior Court judge who is telling the parties, go out there and sell it. But I am too nervous about this specific formula being too narrow a mechanism for the court.
So your idea would be that we give a judge power to go decide it, but we don't force his hand on how to do it, or on if to do it.
And but what I am saying to the judge, this is the formula you like, and I'm requiring that you make findings relative to these factors. I think that's a compromise I'm offering for the committee's consideration.
If I may, Mr. Chairman.
Any further discussion first on that point? Okay,
Well, yeah,
Mr. Lindsey.
no,
I'm ready, just.
And this is on Representative Oliver's point, because like Representative Fleming, I'm sympathetic to your point of view, but I'm trying to say, trying to step back and go, okay, Judge, if you don't follow what we're saying you can do, what are the parameters for the judge to make a decision? Surely there's got to be some type of factors or parameters that he's got to look at that someday perhaps the Court of Appeals judge will look at to see whether or not he abused his discretion or not. And I'm at a loss to figure out what are his parameters if he doesn't follow this formula. And I understand the flaws in it, but what are the what?
If the amendment were drafted this way, just for the purpose of discussion, the judge shall consider the purchase price based on the following specific finding, and shall make specific findings of fact relative to the purchase price.
Still leaves open to
It still gives him
uncertainty.
or her, it's not a mean, my intent, and I'm happy for y'all to improve the mechanism of our intent, is to require the judge to make findings of fact on these factors, and give the judge the requirement that these factors be analyzed and considered, not impose specific formulas.
If you could, again, shall consider the following.
Factors relevant to determine the purchase price and shall make specific findings of fact relative to said factors is an alternative amendment that I might, as I speak it, would like better.
Give us your wording again from the point the judge.
I'm going to give you a second attempt.
All right.
The judge shall consider the following specific factors to determine the purchase price and shall make specific findings of fact relative to said factors.
Mr. Fundry, you had a question. Look on your face.
I couldn't keep up with her in writing.
The judge shall consider the following factors to determine the purchase price.
Let's slow down a little bit.
The judge shall consider
the following
factors to determine the purchase price, comma, and shall make specific findings of fact relative to said factors, which may be superfluous here. She may be required to make findings of fact.
Okay. After purchase price, determine the purchase price and what?
The judge shall determine the following factors to determine the purchase price.
Stop. You read it again. You said the judge shall consider the following factors to determine the purchase price and
shall make specific findings of fact relative to said factors.
Hold on just a minute, please. And shall make specific findings of fact
relative to said factors. I'm keeping the word shall and I'm replacing the word determine with consider and requiring the judge to make findings of fact.
Can I suggest relative to the following factors? All right, let's stop for a second. I'm going to read back what I have. May I? We're striking after the judge shall. We're striking determine the purchase price as follows. And we're going to insert and read as follows: the judge shall. And then from that point, consider the following factors to determine the purchase price, comma, and shall make specific findings of fact relative to the following factors. Mr. Fleming.
No, I think that solves what I was worried about, and also accomplishes what you want. He's got to find the price now, and he may consider these or use a different form if he thinks it's better.
Yes.
Yes.
Clarification. Representative Oliver, is your language in respect to shall consider, is that tantamount to including but not limited to language, in your opinion? Okay. Thank you.
We have a motion. Further discussion on the motion. You read back your language. Everybody understand the motion? Mr. Bondrick, you have it?
I have it, sir. I believe the comma's out of place, if you don't mind deleting the comma.
All right, so take out the comma after price. So read, the judge shall consider the following factors, determine the purchase price, and shall make specific findings of fact relative to the following factors, colon. Any further discussion on the motion? Read again.
I understand what you're saying, but I don't know how that's different than the way it reads now. I don't see the difference because it's a practical matter, those shells modify everything else. If you shall make findings related to those factors, then how then do you bring in other factors?
I think that my intent is to not limit the judge to consideration of only those factors, but to give the judge broader authority beyond those factors. Have I not accomplished that?
Well, I'll read it one more time, then we'll suspend discussion. The judge shall, at that point, as we are on that line 7, strike out, determine the purchase price as follows. We will insert under the motion, consider the following factors to determine the purchase price, and shall make specific findings of fact relative to the following factors, colon.
I read that the judge shall determine the purchase price, and he shall consider.
Yes, sir, Mr. Tumlin.
None of this amendment, then, we're not, anything can be used, any standard,
Any other factors.
any other factor.
Shall consider. Further discussion. Mr. O'Neill.
Chair, do you agree with the interpretation of Ms. Oliver's interpretation that we're delegating our right to promulgate policy to judges?
We are delegating. I think we're defining to the judge those steps to be used in determining that value. We're defining it.
I thought maybe I'm totally confused and misunderstand. Did I hear you say, to offer the amendment, that you thought the language gave the judge the right to consider any other factors that we're not promulgating here at all?
That is my intent, and I do that as a matter of policy, because I don't think that we at this table should tell Fulton County what they should pay or sell a piece of property for. I think that the purpose of having procedures to have an independent entity, judiciary, resolve a dispute, as they do 10,000 times a day, and that we're giving them very specific guidelines as to how they want them to do it, but we are giving them a level A.
Not if we incorporate your amendment, we're not giving them specific guidelines. We're giving them some guidelines we'd like them to go by, but they're not bound at all by doing it. We're saying, here, judges, y'all take our problem. We're advocating our authority to deal with it.
When we have a condemnation, you're an eligible, just think it's eligible. And some of those, I don't think we're telling the judge use this formula to tell what the price of it is. We're saying the judge figure it out. We're doing something much more directed here based on what it is in the law. And I accept that, but I don't want it to block.
Yes, sir, Mr. Fleming.
I understand Mr. O'Neill's concern, but say to the judge, here's the things you consider, but you make a final decision, and there's a factor over here or a factor over there that you need to bring into play, do that. Whether it be equitable powers, whether it be any other legal method you can think of, including condemnation. We do that all the time. That's why I'm not uncomfortable with doing this.
Call the question. The question is on the amendment offered by Ms. Oliver to line 7. Everybody understand the motion? All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Let's have a show of hands. All in favor of the motion signify by raising your right hand. 4, 5, 6. All opposed to the motion, raise your right hand. 2, 3. 6 to 3, it passes. Any further amendments to Senate Bill 569? Mr. Lindsay.
Perhaps to seal off the concerns raised by Representative O'Neill, Chairman O'Neill, and also given the fact that the factors seem to end suddenly at I with no period or termination point, I would suggest that an additional J at line, beginning I guess at line 15 on page 5. That would read, such other factors as may be relevant to the specific facts in the matter. I do want, if you've got that down, what I'm looking for is, I don't want to give the judge a complete open-ended pass to suddenly decide that what house rather the moon is in today he can rely on. I want him to have to lay out the specific other factors that he's relying on, so that they can be considered, if necessary, by appellate court in terms of the fairness of it. I think we got a little bit too open-ended now. I want to try to close off.
Read your proposal again as J.
Proposed J, such other factors as may be relevant to the specific facts in this matter.
May be relevant to the
specific facts in this matter. That's what I have, and I'm open to any improvement on that language.
Relevant to the specific facts. I don't quite know what the other facts would be as far as trying to say facts of facts. You're setting out through I, what are the factors?
What I'm trying to do is, if you're going to, Mr. Chairman, what I'm looking to do is say, Judge, if you don't rely on the factors A through I, and if you rely on an additional factor, you've got to lay out exactly what it is to the parties, and it's got to be something that's specifically relevant to the transaction at issue. That's what I'm looking for. Adding it right there. Yeah.
Okay, I suggest the following wording. I must say this is what the committee does, just trying to word it to accomplish what you're saying. Under J, any other factors as may be relevant to determine the disputed value of the property.
That would be an improvement over my language, Mr. Chairman. I would go with that.
May I read that to the committee? Mr. Bundrick, did you get that? You want to read it to you?
We'll read it one more time, Mr.
J, any other factors as may be relevant to determine the disputed value of the property. Any discussion on the motion to amend? Ready, Mr. Bunder? You got that down?
Yes, sir.
All right. All in favor of the motion as stated by the chair, signify by saying aye.
Aye.
Opposed, like sign. All right. I think the motion carries. Any further? Mr. O'Neill.
I don't have a specific amendment, but I've got I guess, a query to the committee. It seems the ogre under the bridge, one of them at least here, is that the county, at least in the Fulton example, is threatening to sell parks that are now located in Sandy Springs and other places to, I guess, grease their pockets or whatever. And what we're trying to do is if it's a park, we want to keep it a park for the city and county residents. I don't see any protection in here that the city can't buy a gifted piece of property for probably a substantially under market value amount based on these formulas and turn around a week later and sell it to a developer.
Where is that? It has to carry under the general law as surplus property, which means there is no further existing need of that local governing body for the use of the property. It has to go through that with a public hearing. I believe Mr. Bundrick, you correct me if I'm wrong, or Mr. Lundy, you're a city county attorney. You have, if any time a local government declares something surplus as property, it has to state it by resolution, have public hearings before it can dispose of the property. And then the disposal of it is by, as you point out, by bid purpose.
Here's a pretty good process you have to go through to sell a city property. It doesn't stop you from doing it. But I think what probably stops you more so is the fact is that the city council starts selling off pieces of parks. I don't think that'd be city council very long. I mean, somebody has to have the authority to buy or sell city land, or it makes sense to be the council. There's a practice from that. They start doing that on a regular basis. I don't think they'd be around for long.
I think it could be stopped too by. What is?
They didn't sell a park. They took somebody's house.
Oh, okay. I think it could be even stopped through court action by a citizen saying it's not surplus property. It is under public use and continues.
Yeah. Wouldn't we be prudent if we put some sort of maybe reversionary right in these conveyances if it weren't continued use for what they got it for? I mean, that's really what we're trying to prevent.
I think go ahead, Mr. Fleming.
I think what we're really trying to prevent is a government stalemate between two parties and allow the government closest to the people in that situation to control what's going on, rather than the Fulton County Commission allow that city council to control what the future use of that park is going to be. The decision making will be done at the local level rather than done a little further away at the county level.
Any further amendments? Back to the main motion. The motion is to do pass as amended. Any discussion on the main motion? Ready to vote? All in favor of the motion to pass as amended signify by saying aye. Aye. Opposed, like sign?
No.
I think the ayes do carry. Thank you, Senator Weber. We'll get you a committee substitute. We'll have that for you.
Thank you, Mr. Chairman and members of the committee. I appreciate all your time today.
We're now to a previous bill we had, which is Senate Bill 573. We had Senator Carter bill. This is really in the committee's. What action was taken this morning, Mr. Lindsay, as far as 573 in my absence, please?
573 was taken off the table, Mr. Chairman, and is now ready for the committee's consideration.
All right. We're back to considering Senate Bill 573. Let me find mine. Here we are. Any discussion on Senate Bill 573? Do I hear a motion? Yes, sir.
Mr. Chairman, I do think, if I remember right, we now have two bills rolled into one under the same number. Isn't that correct?
That's correct.
And Section 1 is a House bill.
Previously, yes, sir.
Section 2 and Section 3 are now what started out as Senate Bill 573.
That's correct.
Is that right?
That's our prior hearing on the bill.
Mr. Chairman, I'd like to make a motion at the proper time.
All right. Well, Ready for a motion on the bill itself? First.
No, sir, this is an amendment.
I understand. First, we have to have a motion on
Okay.
the bill. Got a motion, so move what? Do pass?
Do pass.
The motion do pass. Any amendments to the bill?
Mr. Chairman, I've got one amendment.
Yes, sir.
Page 28, after the word seller.
Page 28?
I'm page 11, line 28, I'm sorry.
Okay.
After the word seller would be a period. Strike the remainder of line 28 and all of line 29.
Go back and repeat your motion for me. I'm sorry.
Yes, sir.
The amendment
On line 28 of page 11,
Yes, sir.
after the word seller, there will be a period placed there. The balance of line 28 and all of line 29 to be stricken.
The motion is amend by striking line 28 the following, and said payments could adversely affect recovery of escrow funds. Any discussion on the motion?
Could I ask the author of the amendment what his intent is?
This was a notice provision that was added that it's a notice provision that Representative Bruce added, and about that this could adversely affect the recovery of escrow funds.
Any other questions on the amendment? Yes, sir, Mr. Bruce.
Because I'm confused. When you spoke to me the other day, you said you didn't have a problem with it. So what?
I don't have a problem with it, but I'd like for it to be out of there. If it stays in, I'll vote for the bill. I'm not going to vote against the bill.
Okay, but I guess I'm trying to understand if there's no problem with it, why take it out?
That's up to this committee.
Any discussion, further discussion on the amendment? Amendment is to strike. All in favor of the amendment as stated signify by saying aye.
Aye.
Opposed, like sign?
No.
Let's have a show of hands. All in favor of the motion signify by raising your right hand. 1, 2, 3, 4, 5, 6. Opposed, like sign. 1, 2, 3, 4. The motion carries. Any other amendments to Senate Bill 573? Prepared on the main motion. The motion is do pass as amended.
Mr. Chairman, I think there's another amendment that council just pointed out to me.
All right.
To make it. Oh, yeah, I see. That's true. Mr. Chairman, let him explain it to you if you don't mind.
All right, Mr. Belafonte, please, sir.
On section 3, subsection C, starting on line 34, page 11, if there was just an amendment to put in section 2 of this act, or excuse me, section 1 of this act shall only apply, and then as it is, because section 2 doesn't have a cause of action provision. So just in addition.
The actual only, all right, looking at line 34, section C, this act shall only apply with respect to causes of action or claims arising on or after the effective date of this act. Now, we're really speaking about under section 1, correct?
Correct.
Okay. Section 2 does not contain anything as far as a cause of action provision. Does it make any difference then?
It doesn't make any difference, but it's just a lot clearer. And if somebody wanted to make the argument that there's a cause of action somewhere hidden in section 2, there's support based on the way it's written. But if it's the intent of the committee that there is not any type of cause of action in section 2, then it could be made clear just by adding section 1 of at the start of subsection C.
Okay. So what you're saying is put in the word section 1 of, and then this act be not capitalized but small t. Section 1 of this act shall only apply with respect to causes of action or claims arising on or after the effective date of this act, etc.
Correct.
Any discussion on that? I'll make it as a motion. Yes, sir. Mr.
Chairman, I'm not really sure why we would want to do that, because in the event somebody should argue that there's a cause of action in section 2, while it does not appear that's the case, wouldn't we want all claims or causes of action treated the same?
If there's a cause of action that comes under section 2, it won't be effective until the effective date of this act, which is, what is the effective date, I guess? Section 2 is effective July 1, section 1 is effective immediately upon the signing of the government. So I get back to my original question, where are we making any change other than just clarifying section 1 of this act shall apply with respect to cause of action or claims arising after the effective date? Okay, so I'm putting out a question. Do you want to consider that as a motion to amend? Any question on it? No desire to pursue it. All right, we'll strike. We'll leave it as it is. Section C is left as it is, saying this act shall only apply with respect to cause of action arising after the effective date of this act. Is there any other discussion or motions? No further motion. Go back to the main question. The question is to pass Senate Bill 573 as amended, as a House substitute. All in favor of the motion signify by saying aye.
Aye.
Opposed, like sign. Ayes have it. We have a do pass as a committee substitute. We're going to take about a 5-minute break, and then we're going to proceed with the what we had scheduled is 9:45.
You got a minute?
5 minutes, please. We'll get back to places. A lot of things are Let me ask you a question. I'm looking at your bill.
Okay.
If we go over to page 2, the top of it,
Yeah.
now I want to read this. It says, "It shall be the duty and obligation of every person to pay any and all property taxes due to the state or its political subdivisions authorized to levy such taxes." Now, the law in Georgia at the current time is ad valorem taxes are only a debt of the property, not a debt of the individual. Meaning that if I don't pay the taxes on my property, they can ultimately levy and take the property, but they really don't have anything against the individual, the property owner, me, for not paying the taxes. Are we changing that law?
I'm going to ask the person who helped me draft the bill to
All right.
come up and...
Good.
but
I'm glad.
I always felt like that when I got the bill, I was the one that was paying it, not the property.
Well, you are paying it. If you don't pay it, then your property is subject to being confiscated, we'll say, because of it.
Yes, sir. I'm Dan Ray, Tax Commissioner of Rockdale County, and had the pleasure of helping Senator Williams on this bill. No, there's no intent there to change the law. I think it was just a reiteration of make people fully understand from our point, because we hear all the excuses in all the world, but I didn't, from one end of the spectrum to the other about paying their taxes, and I think the intent of that was just a reiteration to make it very plain that you're obligated to pay those taxes, and there's no excuses. You have to pay them. So there's no.
You see what I'm saying? As far as the language now makes it an individual, I think, obligation. And do you agree with what I was saying earlier as far as the statement of the law in Georgia is that the taxes, because you as a tax commissioner can't go file a lawsuit against the individual.
Against the person, then if the person refuses to pay, then we go against the property.
But you cannot, if I understand the law correctly, file a lawsuit, let's say, to say we're going to sue you for failure to pay your ad valorem taxes on that property.
That's correct. We just go after any property he owns.
That's right. That's correct. And so he doesn't incur a personal debt for the levying of taxes his property does on ad valorem taxes.
We can go after him on any property that he owns in the state.
Correct. Now the difference is on
I couldn't go after his income.
Personal property taxes, you can do that. You can go after the individual on personal property taxes because they disposed of it and they've received the monies. But the property itself stays there as the collateral, will say, to the obligation for the tax.
Mr. Chairman, I think you said you could go after any property the person owns in the state of Georgia?
That's correct.
So it's not just the subject property?
Not subject property, right.
I can deliver that 5-8 to any sheriff in any county where that person owns property.
That's right.
That's why it's addressed to any and all sheriffs. But that was the intent. That was not the intent. Just a restatement of the obvious fact that we're to pay our taxes, Mr. Chairman.
Mr. Chairman, I don't have a problem changing that, or it's not the meat of the bill. But,
and the main point was we just wanted to get some definitions of some terminology, because owner of record is a technical term. It's the owner of January 1st, and we start using terms and there are new owners and owners of record. We wanted to get those definitions nailed down.
I think I'm for that principle. That's one of the things we have ongoing difficulty about.
Yes, sir.
Any further questions of the presenter on the bill? All right.
I've got one.
Yes, sir.
One small item that needs to be changed. Just a typo. Page 1, line 20. That B needs to be changed to C.
Otherwise, it's referring to itself.
Yeah. Okay. So on line 20, we're changing the in parentheses B to C.
Right.
Okay. Any other? Yes, sir, Mr. Tumlin.
I think we get the new owner's address a lot quicker if we change that archaic rule that you're going to file your homestead exemption through January or March.
Well,
most people close the house in April and they'll.
As of July 1st this past year, that law did change. They can now file year-round with March the 1st of the year they're filing for is the cutoff deadline. So if you do buy your house in April, you can come immediately to the tax commissioner's office and file for the following year. That is correct. You got that.
More new owners suggestions.
Yes, that helps too. Yes.
Good point. Anything further by the committee of the presenter? Well, just a minute. We'll have some more discussion. Thank you, Senator Williams. We'll open up now for anyone else wish to speak in support of Senate Bill 525. Anyone wish to speak in opposition to Senate Bill 525 or have comments on it also?
Yeah, I just have a comment, sir. My name is Frank Warren. I'll approach if I may.
Please come up to the seat and we'll be able to hear you over the speaker.
I really don't have a dog in this fight, but I did hear the chairman mention something about the FIFA and what its effect was. My understanding, I think I heard you say you thought the FIFA issued for taxes was not a personal liability?
Ad valorem taxes.
Property ad valorem taxes. My understanding, sir, is that it is indeed, and I don't know if it makes any difference, in this particular setting, but the FIFAs, when they are issued, they are a classic form of what would come out of a judgment from a court, which says go out and seize the property of the taxpayer. So my understanding, and again, I don't know if it makes any difference, but my understanding of the law is that it is not only a lien against the property itself, but it also is a personal liability of the defendant in FIFA. So to the extent that that means anything to the committee, I just want to offer that up, sir.
Thank you, sir.
Thank you.
Thank you. Anyone else wish to either speak regarding the bill in the audience? It's in the breast of the committee. Any discussion among the committee regarding Senate Bill 525? Do we have a motion? It's been moved to pass. Do we have an amendment? I want to offer the amendment as discussed by Senator Williams on page 1, line 20. Change B in parentheses to C in parentheses. Any discussion on the amendment? All in favor of the amendment signify by saying aye. Aye. All opposed, like sign. The amendment carries. On page 2, just for the sake of being sure we're not changing what may be current law, Senator Williams, if you're open to it, I'm going to ask that beginning of D underscored be removed and go back to the original language starting with the capital N as the beginning of that sentence, which will read, no execution shall be issued against any person, etc. So the proposed amendment will strike what is the beginning of section D, underscored. Any discussion on the amendment? All in favor signify by saying aye. Aye. Opposed, like sign. The ayes have it. Any other amendments? We have back to the main question. We have a motion due pass on Senate Bill 525. Any further discussion on the motion? All in favor of the motion signify by saying aye. Aye. Opposed, like sign. The ayes have it. We have a committee substitute as amended due pass. Thank you, Senator. And next we have the Tax Execution Senate Bill 585. You have in your files a amendment to this bill. I don't have it in mind. I took it out. That's right. Let me have yours, if I may. Please, ma'am. Mr. Schaefer, glad to have you here. Thank you. I wasn't sure you were going to be able to make it. Thank you. We're presenting Senate Bill 585. Do you want a copy of it?
What I'd like to do, Mr. Chairman, since I'm participating in another meeting that's going on right now, is simply thank you for your work on the committee substitute, which I've had an opportunity to review, agree with it as you prepared it, and with that having been said, would like to be excused. Have you explain the substitute?
I'll be happy to do it. That's fine. We've had a good bit of work going on back and forth. Thank you, Senator Schaefer. If I may proceed, I'll just keep my place, and let me tell you the history behind some of the provisional 585. You'll recall that we had a House Bill 931, which was modifying and putting back into place, not modifying, but putting back into place some statutory provisions addressing how and under what circumstances there would be a sale of tax executions, and when sold, certain standards to be used by the party we call the transferee in the handling of tax executions by notice provisions, and even the question about allowing the taxpayer a place to go and pay off those tax executions when they were ready to be paid off if they were in delinquent status. That bill did not pass the House. It came not back, but we had the other bill which came out of the Senate, 585. I have been working with various parties, which we'll get into in a moment, talking about specific changes under Senate Bill 85 to include some of the provisions of 931. Specifically, I'm going to go through and talk about the items in this bill that were incorporated. We went through again under Section 2. Let me go back. Section 1 is just to clarify what we understood to be the law, and that is that the section of the Code 91336 is not intended and shall not apply to the sale and foreclosure of tax executions. So that is added as a sentence on page 2 at the top of the page, lines 6 and 7. Section 2 of the bill gets into the specifics of the structuring of the standards I'm speaking of as far as how tax executions will be handled through the tax commissioner's office with the sale of them. We have the definitions defining various terms used in this section. Let me go back. You may recall that the entire section we have defined in here is out of Code Section 48319 was deleted back in 2002, and by its deletion there was really nothing in the law that gave any standards to be used by the tax commissioners nor the persons as a transferee in how to handle the collection of these items. So we did put back in the law this section, which now gives and addresses questions of notice and how notice is to be given. The big problem comes about, as Senator Williams talked about, the transfer of his property. Tax bills do not go to the right person sometimes because you've had a transfer, you've had a new buyer of the property, a new owner of it. There may have been given to the post office a change of address which lasts, say, up to 6 months, and then it lapses. So unless it's continued, then the bill goes out, and nothing is done as far as that bill being delivered to the taxpayers, returned to the tax commission. And unfortunately, too many times there's not a follow-up to find out why was that tax bill not delivered. So what we're trying in this situation, if there at least occurs with the transfer of the tax execution to a transferee, there's going to be a notice sent out by the transferee, and if that notice is not delivered to what they believe to be the appropriate party who is the taxpayer of that property, it comes back to them. We've asked that certain steps under the law be taken, called the due diligence, to make a inquiry as to why there was not a delivery. And you'll notice that we have the language page here. Defining due diligence on page 2 says due diligence means the performance of a diligent search to ascertain the actual location of the record owner of the property. The following actions shall satisfy the diligent search requirements of this code section. Sending notice by first-class mail, certified mail, or statutory overnight delivery is required by law. If the notice is returned undelivered, the following actions shall satisfy the diligent search requirements of this code section. Due diligence shall include checking telephone directories for the county wherein the property is located, checking the records of the tax commissioner of the county wherein the property is located, or checking the real estate records of the clerk of the Superior Court of the county wherein the property is located. So we're asking that something be done beyond just sending the letter when it comes back undelivered. Primarily is to keep the taxpayer informed that there was a transfer of the tax execution and giving information as to the manner in which that tax execution can be paid, because if you look on page 3, we have the information under section C beginning on line 23 the fact that it's sent out in the notices to include the name, mailing address, telephone number of the transferee's business office, the amount necessary to satisfy the execution, and other information deemed appropriate by the transferee. For instance, they may be offered to allow the taxpayer an ability to pay off this execution over time by doing an installment basis to contact the office for that purpose. We also recognize that if there is a sale of a substantial amount of the tax executions to a third-party entity as a transferee, there is going to be an office maintained by that transferee through which the taxpayer can go and locate an individual to do business with to get the tax paid off. This happens, for instance, when you have someone selling their property or going through a refinancing or a second mortgage, and all of a sudden it comes to light there is a outstanding tax execution. There's an urgent need many times to get that resolved, and rather than have it be done through the mails, we've asked that the tax execution transferee maintain an office within the area where that tax execution tax commissioner's office is located. Those are the main points that we have about the bill. This is an important bill, especially as to Fulton County. It is the major county that uses the service of transferees to help collect taxes. And if you notice in reading the paper recently, the Atlanta Journal-Constitution brought up the fact that we've had, I think, a $40 million shortfall in taxes from last October due to the fact that we had a court case in December that acknowledged an inability of the tax commissioners to sell tax executions because the fact that the General Assembly in 2002 did away with that ability. And so without this language in place, the question now comes, what will happen as far as the ability of the tax commissioner's office and the operation of the county government and the operation of school boards in Fulton County, whether it be the City of Atlanta or the Fulton School District, to receive sufficient funds to provide for continuing needs of operation on this annual basis this year. That is, in general, covering the provisions. I'm going to open it up. We've had discussion on 931, yes, in the past. We have not talked about 585. So if there's someone here who would like to speak in support of 585, I'd like to give you a limited time to come forward and express your interest. Let me get Ms. We've got the president of the Fulton County School Board here, Ms. Dean, Ms. Gail Dean. If you'll come forward, I'll let you be the first to speak.
First of all, Representative Willard and members of the committee, I'd like to thank you for your support of the Fulton County school system and schools and students in general. And I know this has taken a lot of time and work, and I appreciate you allowing me to speak. Mr. Willard, Representative Willard, I usually call you Wendell, so it's kind of unusual to sit here and formally address you. We share constituents from elected areas. And we've met starting last summer. I've come to your committee before and testified. And the school system yearly looks to a certain amount of revenue based on collections from local taxes. And in the Fulton County school system, our local tax base is about $400 million. About 10 years ago, we collected about 88%. And now we're up to 99%, and the change in that collection rate is specifically due to the sale of tax liens. We've budgeted and been able to be revenue neutral and roll our taxes back based on the 99% collection rate over the last 10 years. And we, again, as you pointed out, have budgeted for next year $40 million less based on recent court cases and fear that Senate Bill 585 or 931 or whatever form would not come through, and the school system would drop back to that 88% collection rate. Well, that $40 million represents almost 500 teachers to the school system. So we have a we're in the budgeting process. We have a real critical need to pass Senate Bill 585 and the substitute from your committee, in that we can budget next year for that $40 million. That again is almost 500 teachers. So we aren't here to and I've said this to Representative Willard, to write tax law. That's not what we do in the school system. We educate students, but we do know that we have to get the revenue to be able to do that. And I, again, support your substitute, Representative Willard, and I thank you for the interest you've taken in supporting the students of Fulton County. And I do hope that the committee passes the substitute in its current form without any changes. And again, thank you.
And my edge, you've had to dip in your reserves as a means of trying to get yourselves prepared for that need for this year.
Well, we have done a $21 million budget adjustment. The net after some other revenue was 16. You saw that in the paper. Right. And next year we're budgeting the $40 million. So thank you very much.
Questions? Sure.
Yes, Representative Thomas.
I was simply making sure that you. I guess from just my standpoint, just for the benefit of the folks who've just come in on the committee, this proposed committee substitute was something that was worked out between Senator Schaefer, Chairman Willard, the Fulton County School Board, the Atlanta School Board, and the Fulton County Tax Commissioner. Correct.
More directly, is the last part is the people who are involved with the purchase of tax execution.
Right.
It doesn't change anything in the bill as far as the duties of the tax commissioner.
But this was something that was being signed off by all the committees.
And understand, again, we have to look to the folks that collect the taxes for us to tell us whether or not they can, and I understand that the tax commissioner and City of Atlanta schools and are all now supportive of this substitute. So
thank you.
Yes.
Did you have something?
Representative?
In this particular situation, is the law, Mr. Chairman, I guess I want to know, is the law right now based upon what the General Assembly passed? It says that the tax commission must collect taxes, and so is
as the law is right now, the tax commissioner is not capable of selling tax executions to third-party transferees because of two things. In 2002, the General Assembly, in its wisdom back then, did away with the provision under 48, I'll lose the chapter number, 48.319 and 20. Let me go back. 48.319 and 20. And because of doing away with it, the court this past December recognized that having voided that law, there was no longer an ability for the tax commissioners of Georgia to sell tax executions. That's where we are.
But does this bill then go back and say that he can?
This recognizes the ability of tax executions to be sold by a tax commissioner. Yes, ma'am.
But does it mandate that it be done, or is it a may or is it shall?
It's a may. The tax commissioner may do it. In his sole discretion, the tax commissioner may do it.
Okay. And let me just follow back up to, I was able to get a copy of something says Education News School Budget Deficit Averted, and as a part of it, it just mentioned that you were saying that that maybe you made up some money from the Hurricane Katrina and whatever.
Well, what happened is this year.
Let me finish the question.
Okay, I'm sorry.
Okay, so the question is, just for the record, once funds came to the Fulton County school system for Hurricane Katrina, they were not designated. They were just designated not just for Hurricane Katrina students, but just money that could be used for anything in your budget?
No, what happened was we had a massive deficit relative to, it cost about $8,000 a student to educate the students. We received approximately $6,000 from the federal government, so we made up the difference for Katrina students through the reserve fund, as well as there was another budget deficit of $21 million due to the appeals case that happened relative to the sale of tax liens. And then we had some additional revenue from collections, other local collections that weren't from real estate in the budget. So the net change that we had to take out of reserves was $16 million. But part of that was additional cost for Katrina, less the revenue from Katrina, plus the additional revenue locally, less the cost of not being able to sell tax liens, and so it goes into a pot. But actually, we ended up spending a lot more on the Katrina students than we actually received.
So the discretion with this is with the tax commissioner as to whether or not he does sell it or not. And the reason you're supporting the bill is you're hoping that our Fulton County Tax Commission will use this bill as a way to begin to sell tax liens again in Fulton County.
Yes, we understand that if this bill passes, he will be able to do that, and in fact, some of the revenue lost from last year can be recouped, and additionally going forward, we won't have to project an 88% collection rate. We'll actually be able to collect a 99%. Okay.
Thank you.
Yes, sir.
Anyone else have any questions? Thank you,
Okay.
President Dean.
Okay, thank you.
Anyone else wishes to speak in support of Senate Bill 585 as a committee substitute? Come forward, please.
Thank you, Chairman Willard, and thank you, committee, for an opportunity to be heard. I'm here as a taxpayer and a parent. I serve on 2 boards of Chattahoochee High School and Taylor Road Middle School and the North Fulton Council of PTAs. But I know a lot of parents in South Fulton, too, who are very, very concerned because the cuts that will happen based on an 88% collection rate will happen all over the county. The principals have already told parents at the board meetings this is going to happen. It's going to be major teacher cuts and or program cuts that are very valuable to the taxpayers here. That's why we pay taxes as we do in Fulton County, because of our great schools. So we would ask you to support the House substitute to Senate Bill 585, because it would allow Fulton County to budget on the 99% collection rate, and it will forestall those massive cuts that our principals are telling us. And we would ask that you support schools and taxpayers who pay their taxes over people who don't pay their taxes. And we don't. Thank you very much.
Appreciate your comments. Anyone else wish to speak in support of Ms. McRae? Come on up with your officials from the Tax Commissioners Association.
Jean McRae with the Georgia Association of Taxing Officials. We appreciate you working so hard on this bill and being willing to listen to us. It's been a good process, and we thank you. This is Dan Ray, the Tax Commissioner from Rockdale County, and George Wingo from Fayette County. And I think Dan wanted to ask one question.
To echo what Jean said, this has been a 2 to 3 year process as we've gone through this. We've been up there many, many days, and I was somewhat disappointed the other day when 931 lost all that work. So this is very good. We appreciate this. There's several other things that you didn't even point out that are great for us, because it defines some issues dealing with the tax sales, redemptions of tax sales, what to do with the excess funds so that we don't continue having money floating around out there that can be invested improperly.
Correct.
And one of the greatest things I like about it is when somebody does redeem their property, they do not have to pay the real estate transfer tax fee. I always felt like that was like kicking a poor dog when he's down. And so thank you for putting that in there. But
thank you,
George,
Commissioner Ray.
For any ask
Commissioner Wingo, anything you want to add to it?
Nothing, Mr. Chairman, except to say thank you for listening to us. We think it's a good piece of legislation. We support it. We appreciate the hard work you folks have put into it.
I appreciate all of your input, too. I guess I say because during the last year I've had this as an ongoing concern, trying to get this issue hopefully put to rest and behind us for some period of time. Thank you. Anyone else wish to speak in support of? Yes, sir.
Hi, Chairman, committee members. Thanks for letting me speak again real quickly. I, too, agree that this bill is very good for the schools and good for the county. And we have experience.
Your name, please.
Oh, I'm sorry, Jim Meeks with Mooring Financial.
Yes.
We're a purchaser of or transferee of tax 5-phase in Georgia and in 20 other states. And I've seen legislation in 20 states, and this is a good piece of legislation the way it is. I had 2 quick comments to make that I think we'd like to see, because we feel it would encourage more competition in the process. Brad is passing around proposed language. Right now the bill is silent to how the process would work from a transferee and a tax commissioner standpoint, how we would go about requesting transfers, and if there are competing transfer requests, how that would be handled. And all we're asking for is a provision that says, upon request, that the commissioner would at least just spell out, this is how we're going to do it, before the transfers are made. And we believe that that would encourage competition, because a company like ours and other companies that are national purchasers want to know that there would be some sort of set of rules. It's not dictating what the rules are, it's just asking for it to be somewhat of an open process. So that's one comment I have. The second comment is the committee substitute for 585 added provision G under section 2, which you just talked about. That's the one about having an office within 50 miles of the tax commissioner.
Yes, sir.
And I think that's a great idea. I believe that it needs to be a process where the taxpayer can come and make payment, and it should be easy for the taxpayer to make payment. However, this could have a tendency to limit competition, because for $2 million of transfers, it might not be viable for a company to set up an office if that's all you're able to purchase. If you're able to purchase, say, $10 million, then of course that would make economic sense for a company like ours. And so my proposal would be to just increase that amount, but I do believe in the idea of the taxpayers having easy access to the transferee.
Thank you, sir.
Thank you.
Anyone else wish to speak in either support or opposition to who are you?
Opposition.
Come around, Representative Dean.
There are some other people who want to speak in opposition. Mr. Chairman, I think most of you know my position on this legislation, and it's not really opposition to the legislation, because if we assume that we're going back to selling 5-phase to third party, this is not a bad piece of legislation. But the General Assembly in 202 spoke very loudly to stop the sale to third party. And the reason we made that decision was that somebody who have taken the oath of office, appointed by the county commission, ought to be the one to sell these 5-phase. We changed the law in 203 that the tax commissioner of Fulton County would be elected. So the people of Fulton County elected the tax commission, and the purpose of electing tax commission was to collect taxes, not to sell those taxes to third party and allow them to do what we elected the tax commission to do. Just that simple. That's just plain and simple, that we elected Dr. Ferdinand in Fulton County to collect taxes. And when you shift it to third party, you are taking the responsibility that I placed in Dr. Ferdinand to collect taxes. Now, they have come here, and Mr. Chairman, this is no play off anybody, but this is almost criminal, this placating all of this here issue that they brought up today. Before 1994, our school system operated with the way we collected taxes. And when you look at it, everybody's running scared now, saying that they're going to have to fire teachers and they can't educate our kids. And I guarantee you that there is nobody in this school, even now the school superintendent, that can tell me if we were collecting taxes at 88% rate, what the improvements have been in this extra money that the tax commissioner of Fulton County has already increased in his collection. There's no improvement in our school system. I don't think nobody came down here and told you how much we have improved schools in Fulton County since we've moved from 88% to 99%. Nobody talks about Tom Scott in DeKalb County, who collects 99% and don't sell 5-phase. This don't sell 5-phase. 99%, my friends. This is a slap at this General Assembly who spoke in 2002 that we was going to stop the sale. And my good friend, the chairman of this thing, was right with us on that particular legislation, because we realized that we got a problem in Fulton County. And what I really don't understand is that all of these tax commissioners who don't have the problem we have in Fulton County is rallying to start the sale back of 5-phase. I don't understand it, because nobody from outside of Fulton County has come before this General Assembly and said, I'm having problems in collecting taxes. Matter of fact, other tax commissions outside of Fulton County don't sell 5-phase. So why is the citizen in Fulton County is treated different? They don't sell them. And if they do sell them, the small percentage of the ones they sell is so small, we shouldn't have to institute a law to allow this. This is a bill to help greedy investors take advantage of our citizens in Fulton County who have problems sometimes in paying their taxes. And let me tell y'all something. General Motors is finna close. Ford Motors finna close. ATT and Bell South is finna merge. And so if you have financial problems and you can't pay your taxes, these greedy investors gonna buy your 5-phase, because your tax commission gonna sell them. I suspect the investor holding already got a computer outline of everybody who works for General Motors and Ford Motor, waiting on them to get behind in their taxes so they can buy it up and bid it up on the courthouse step. What's right about taking a $1,000 tax bill and building it up and bidding it up $50,000, $100,000 to take somebody's property? And then the mess we got in Fulton County in the tax assessor's office, that you subject not even get a bill for your taxes. Nobody's talking about that. All we talking about in this legislation is giving these investors a right to buy and making our tax commission sell to third-party investors. That's what this is all about. This ain't about no fairness. This ain't about cleaning up the tax assessor office in Fulton County. This ain't nothing about cleaning up the tax office. This is about a few people who want to get rich on the backs of, 12% of the taxpayers in Fulton County? 12%? And I tell y'all, if you pay your taxes for 20 years and you get in trouble financially, what we're doing in this legislation is allowing investors to come in and take advantage of you. This is worse than predatory lending. And I ask this committee, before you pass this legislation, think about and put yourself in the same position. That if I got in financial trouble and I couldn't pay my taxes, there's somebody going to be sitting on the sideline waiting on you to get in trouble so they can bid your property up on the courthouse day. Okay. This is a bad way for us to collect tax.
We're short time-wise. I hate to bring it to an end, but if you haven't signed up, is anybody else that wants to speak very, very briefly? I think we've had this issue debated for the last year before this committee numerous times. Mr. Fleming, please, you want to ask a question? Where is the sheet that you signed up, sir? Right here. It's been out there in the front, but it's been brought over to me.
Again, but you talk about basically allowing a private company to come in and do something that the government does in other places. In some places they have government entities that pave roads and fix bridges. In other places they bring in private companies to do that. Everybody elects a city council or a county commission to make sure the bridge is safe so you can cross over so you don't fall in the river and kill yourself. But whether you have a private company fix that bridge or if you have a public company fix that bridge, as long as the bridge is fixed. And the underlying deal is here, we're talking about people who didn't pay their taxes to start with. Now, if you pay your taxes, nobody takes your house.
I can give you testimony. If you've been following this issue, I've been back in this General Assembly since 1999.
Has anybody who ever didn't pay their taxes get the house taken?
Yes, plenty. And not only get their property taken, but have spent money trying to use legal.
Did the people of Fulton County re-elect the tax commissioner?
Sure they did.
All right.
But it's the General Assembly, sir, Mr. Fleming, it's the General Assembly who dictates how the tax office in Fulton County operate. And we spoke in 202, and what we're trying to do now is revert back to 1994. This General Assembly spoke, I don't know whether you was here or not, but this General Assembly spoke in 202.
It's a different General Assembly now, isn't it?
Well, I don't want to argue with that, and I don't have an argument about this legislation if that's what the General Assembly want to do, is to sell to third party. But what I want this committee to understand is, don't get caught up in the scare tactic. Really understand the burden and how we take advantage of people because they didn't pay.
Here's the last thing. Here's the last thing I'll say to you. I understand your passion on this, and I'm sympathetic to that. But it appears that your problem is not allowing tax commissioners to sell to third parties, but how it's being handled locally in Fulton County. Because if my tax commissioner want to do it, I think she could because she does a good job. The problem is not statewide. The problem is in Fulton County.
So that's why we shouldn't do it, is because it's not statewide. Where you come from is operated right. Your tax assessor's office is smooth to have. The tax commissioner doing a good job. He look out for the taxpayers.
So once again, the problem is not selling to third parties. The problem is how Fulton County is handling it.
But it seems to me that if you're not,
I want to bring the discussion. I got many people.
Okay.
Trying to get up here and talk, and I don't want to have an argument going back and forth between two representatives at this point. Now, next one I'm going to call up is John Jamont. Okay. I'll give you 2 minutes, Mr. Jamont. 2 minutes.
Commissioner. Thank you, everybody. I'm here. I got my property back through one of these tax scam in Fulton County. My property worth about $3 million. It cost me a quadruple bypass surgery, plus $300,000 attorney fees. And it was not because of me. My old mother would have lost this property.
When did it happen, Mr. Jamont? When did it happen?
Year 2000. I found out the property taxes for $78. They sold a $3 million piece of property for $72,000, and it cost me $300,000 to get it back through the lawyers, all kinds of problems.
That's why we're trying to put in some.
And the mother of all evil is the sale of FIFA in this county. No other county sells FIFA except Fulton County, and the Fulton County is corrupt. Their addresses are corrupt. Most officials are corrupt in the tax office. Is as it stinks as hell. And I would be very upset.
Not to use any more profanity in this committee room, and you're excused. You're excused, sir.
All right, thank you.
Alicia Gelfond.
Gentlemen, ladies, thanks for hearing from me. I sent in my taxes. I sent it in one day air. Then I get a notice 3 years later. I don't know if you remember me. I was the one that they said, oh, you didn't pay your $1,600 taxes, and now you owe $374,000. It took me all the way up through the Supreme Court to win. And here's the thing. You write your Bill 585, right? And you say, you shall give notice, you shall do this. But then when you go to the courts, the word shall was then interpreted as directory, not mandatory. It means that I don't have to give you notice. You know, people who didn't get notice, when you go to the courts, even though you shall give notice, it's no defense in court. So then we go up to court. Thank God I had a great attorney. We went in the Supreme Court because they also sold my address under the wrong name and the wrong address. But what happened is the last year, as we were going up to the Supreme Court, all of a sudden I get a refund from the county for my 2004 taxes. I call up the county and go, why are you giving me a refund? They go, you overpaid. I go, wait a second, I'm not going to fall for the same bait and switch again. So I knew enough this time to ask who paid my taxes, because the last time I forgot to ask who paid my taxes, and I thought it was paid. And I know this time I checked, made sure my check was cashed. They go, oh, I don't know. I go, well, you find out and you tell me. And then all of a sudden I find out that two companies that I don't even know came in and paid my 2004 taxes, and the county gives me my check back. Next thing I know, Bob Proctor is up in front of the Supreme Court to reconsider. Oh, Alicia Gelfond didn't pay her taxes. I go, wait a second. I go, oh, yes, I did, because I did not cash the check that Fulton County gave me back. They have my check, and I have a 2000 surplus. What's happening is, in the courts, the level of corruption. Bob Proctor is probably one of the smartest attorneys I've ever met in my life. He's probably the most corrupt, and he'll lie. So the thing is, when you have to go in court to defend it, even if you
ask you not get into personalities,
okay,
ma'am.
it's not a personality.
Not personalities. Don't call somebody a liar in my committee.
I'm sorry. I'm sorry. What I'm just trying to say is the regular person can't defend against it, even if corruption is taking place. If you feel like there's this good old boys club going on there, it is. And it's really hard so now if somebody's working 50 years for their property and something happens in 45 days, according to your bill, it could be sold at the courthouse steps. This is my suggestion to you. You want to get the people you have to collect taxes because we need these taxes to keep what's going on in the county, but you don't want people to be taken care of.
Get to your suggestion.
The suggestion is you wait 5 years. If you're multiple losing taxes, like someone's not paying year after year after year, then you know there's a problem. Then you have to go through the steps of let's find out what it is. But if some person misses 1 year and then the next year they pay and the next year you pay, then you know it's an error. Would you rather pay $1,000 and keep a 200?
Time is up, Ms. Gelfond. Thank you. Any questions to Ms. Gelfond? We have next Mr. Frank Moore.
Thank you, Mr. Committee Chairman and Committee. Thank you for hearing from me. My name is Frank Moore. I'm a lawyer. I've been involved in these cases for 4 years, and I've seen an awful lot of stuff. And what I call this bill is the Vesta Ferdinand predatory lending bill. It is probably the most predatory type bill that you can possibly have. We elect people, we appoint people, they take an oath of office to collect taxes. That is their job. And if somebody's going to take your property, that person should have raised their right hand and taken the oath of office that they're going to uphold the Constitution of Georgia and the United States and not be a party to its evasion. That's the public oath. There's plenty of play for these predatory investors if they want to go down and bid down at the courthouse steps. But up to that point, there's no reason why Arthur Ferdinand cannot go out and conduct and collect these taxes. They do it in DeKalb County, and I challenge the 88% collection rate. There's no reason for 88%. Basically what we've got, and I'd like to address very quickly the economics of the school board, because of course this is a highly emotional issue, and it appeals to a sense of common sense. We can't educate our children. Folks, this is like bringing a factoring business into your company. You've got your receivables and you bring a factoring business. That's what has happened. The fact is, it's all a timing issue. All these taxes get collected. Get Ferdinand in here and he'll tell you that in a very short period of time you get a 99% collection rate, because guess what? People can't sell their property without paying their taxes. People can't refinance without paying their taxes. People, when they get a notice, it goes to their lender, and the lender says, by gosh, we don't want this tax lien, which is superior to ours, to prime us, so then the banks start getting on you. So there is no reason why this 88% collection rate is all a matter of manipulation of public opinion to create fear, to give these predatory opportunists the opportunity to take property from people. Now, let me give you an example. The way this thing works, a lady's been paying her taxes for 25 years. She has a death in her family. She has 2 deaths, her mother and her father, within a 2-year period. She misses a $215 tax bill. She's not a deadbeat. She doesn't know anybody. She owns her home free and clear. She becomes a target of these predators. They come down, they bid in her property at $110,000. Now she's got to come up with $174,000 in order to redeem her property. Now how is she going to do that? Because she doesn't own her property anymore, according to any lender. No lender would loan her money on her property because, according to the deed record, she doesn't own it anymore. So she's got to come up with $174,000. Folks, that is just one example of the kind of ills. You just cannot imagine the ills that have come out of this. Other things that I want to tell you about.
It's going to be short time-wise.
Yes, sir, I understand.
Anomalies, stories about it. Just if you got a problem with the bill, address the bill. I'll give you one more minute.
Well, and I want to address, because what it does is this empowers Vesta. This is the Vesta bill. Let's face it, it's Vesta. Vesta. The difficulty these people have had in finding Vesta. And you know what they do? They use all these different entities. You know, one, it's Vesta Holdings. Then it's Vesta Holdings 1 LLC. Then it's Hartwood 11. Then it's the Harpagon Company. It's always moving and shifting. What I want to tell you about is you've got a problem right now. The way these things are handled, this is not the time to go back to transfer and five-phase. Let it work itself out. What we've got in Fulton County, we've got Vesta was actually performing the duties of the sheriff and sending notices out. They had a facsimile stamp of the sheriff's signature that they were putting on deeds and on documents. They undertook the duties of the sheriff. This is all sworn testimony. I've got Jackie Barrett in depositions taking the Fifth Amendment privilege against self-incrimination. Folks, this is not the time to be going back and regenerating these tax transfers. Fifth Amendment privilege against self-incrimination. We've got a problem in Fulton County the way this thing has been done. It's been polluted. This is not the time. Let it work itself out. I ask you to defeat this bill. I ask you to make Arthur Ferdinand, and this is Arthur Ferdinand, folks, make Arthur Ferdinand do what he was elected to do, collect taxes. He's got the most powerful things that anybody, any collection agency could ever have. He's got the FIFA, he's got the lien, he's got personal liability. He doesn't need to transfer FIFAs.
Thank you.
Thank you.
All right, we've had public hearings on House Bill 585. Is Ms. McRae present still? I don't see her. She left out. Where are you? I can't see you. Have you seen the proposed amendment? I don't know what the tax commissioner's position is on this language about the providing information regarding transferees. Look at that while we talk about it, please, sir.
Had not seen it.
We're in the breast of the committee at this point in time. No further public discussions, except we need to ask comments. Do we have any discussion among the committee members? Yes, sir.
Yeah, we've got it.
Just so I can catch up to date. Been out on this one. Is 585 the same thing 931 was?
Pretty much. We have reduced out some parts of it. 931 had a provision that allowed and really directed the tax commission to continue to be the party that could to receive payments of taxes. This concerned, and it has caused some consternation with our tax commission in Fulton County. So if it is a transfer of this $2 million or more, there will be an office set up by that party who acquires those tax executions where there can be payments made on an immediate basis. That was one of the major changes. Some things we removed also a lot of the provisions right now dealing with the foreclosure sales under 931 that I'm going to address during the coming year to see where we can clean up some problems there that I believe exist. Yes, sir.
I just have a question directed to you or to whoever would like to answer it. But if we have elected tax commissioners, if we elect a tax commissioner to collect taxes, what is the rationale for transferring their authority to some private company or corporation?
It is an option, as I look at it, based upon the law. If we want to have this in place, which I say should be in place, the tax commissioner address that better than I can, but it's an option they have as a means of collecting the revenue for the taxes that otherwise at this moment is not available. And Mr. Wingo or Ms. McRae, you might want to expand upon that.
Well, I think what happens, and in particular Fulton County and possibly in other counties, is that the process of collecting gets dragged out over a 2 or 3 or 4 or 5 year period. This would allow Arthur or whoever wants to sell tax liens to collect those monies immediately. Now, the flip side is when you eventually collect them, you get the penalty and the interest. But it does drag it out, and it deprives the school systems primarily. They generally get about 70% of all the taxes, and it deprives them of those funds. So I think the budgeting process that the lady raised is a good one. They have to anticipate how much they're going to collect at their millage rate, and Fulton, I believe, is at the cap, 20 mills. They have to build that into the process so it can create real budget crisis for some school systems.
Yes, sir.
But my follow-up question to that is, we've heard from several people who have said that there are abuses of the process going on, and my concern is, well, first of all, do you agree that there are abuses going on, and if so, is there any way to address them? I couldn't identify any abuses per se. I think there's room for abuses. I think we've addressed a lot of the opportunity for abuse with some of the things that Representative Willard has built in. The requirement that they maintain an office, 40 hours a week available, and that they notice these people at least once a year that they're holding an unpaid lien.
Yes. Any other questions among members of the committee? Yes, ma'am.
I understand the word corruption, okay, and I understand it, fraud and words like that. But in actuality, I think one thing that did strike me with what Representative Dean said was when he said about, okay, we did something different when we elected the tax commissioner. Okay, and so we think in our mind as a consumer, as a voter, when I go to the polls to vote for a tax commissioner, I think he is the person or she is the person who will collect taxes. It didn't even click to me that the person who you voted for the tax commissioner would then in turn actually give your taxes over to somebody else that you would have to negotiate, work out, find the office 40 hours a week, and all the other particulars. Okay, but then the question was asked, well, did we elect him? Well, we did. But now, obviously, the tax collector commissioner is obviously a race that people now must put on their radar screen, because it's really not a race that people in Atlanta, at least Fulton County, got on their radar screen. Because even in the midst of all the outcry about taxes, people have not thought that maybe they could change the tax commissioner, basically because it's the first time they ever did it. So, but anyway, so
get your question.
So I guess the question is, why do you think? Why did this bill have to be a statewide bill, a general bill, rather than a local bill, if everybody that basically comes to the mic who had an experience that was not righteous was in Fulton County? So why didn't this just end up being a local bill for Fulton County? Let us work it out, whatever. Why impose the concept or the thought of tax selling?
Thomas, you can't do this on a local basis.
No, we got to do it.
Requires general law. It has to be statewide applicability as far as the standards we put in the law. Then with the tax commissioner.
Okay.
Yes, sir, Mr. Bruce. Move first. I'm sorry. Go ahead, Ms. Oliver.
We don't pass a bill, and the status of the litigation is to stop liens. What about the liens that have already been sold or held? What happens to that?
This doesn't address that, and we can't address that. Let me finish. I understand your question. This bill cannot address prospectively what has already occurred as far as those matters of sales before. And all we address is from this point. And that's why if you look at the enactment language back here, we said that the provisions of this act shall apply to all executions transferred on or after July 1, 2006. Executions transferred prior to July 1, 2006 should not be affected by this act. It can't be. And the courts are going to take care of it. That's right. The court. But, yeah. They may have already gotten them, but Ms. Oliver, there's a chance there could be a claim, depending on what comes out of the Supreme Court case, there could be a need to have those repurchased by the county through the tax commissioner from the holders, the transferees, and then a resale of those. That is not addressed in this bill.
So the only thing this bill does in relation to litigation, nothing, it just says we can't do it.
Right. Mr. Bruce.
Do you guys have some statistics showing, on average, whose houses are being sold? Seniors, senior citizens, retired people, whose houses are actually being sold to third parties?
Representative Bruce, I think there's one distinction that needs to be made on this bill. We are not selling houses in this bill. You're selling a lien. There's a very big difference between the transfer of a FIFA and a tax sale or a sheriff's sale.
That's kind of semantics in this sense.
Well, it's... No, not...
Well, it can be.
Well, it can be, but it's not... There really is a big difference.
Let me rephrase it. Okay. Who's being put out of the house because of this process? We have some statistics that show, on average, that we're talking about people are retired, people are senior citizens,
you know.
Whose houses are being affected?
Representative, I don't know that there are any statistics that would give us an answer to that, but I can tell you in my county, I'll be starting to sell properties that are over 3 years old. I don't sell liens, but I'll be selling properties over 3 years old. We started the research this week, and I've only got 110 pieces of real estate that aren't paid that are that many years. Now, Fulton County, I think it's probably going to be 15 or 20,000. 1 year, maybe 5,000, 6,000 after 3 years. But anyway,
So you don't have an answer to my question.
Not
No.
really.
Can I look for this?
One last question, Mr. Bruce. No, you can't. No, sir. Mr. Dean, I'm sorry. We closed off comment.
You can open it up.
Let me get Mr. Bruce finished, please, sir.
I'm trying to understand this because the statistics that have been presented to me from various sources indicate that most of these homes belong to people that are retired and seniors. I don't know about your county. Again, it's unfortunate that you're sitting there. I would prefer that the gentleman from Fulton County was sitting there. But the reality is that it appears that, and I understand the school argument, I'm very active in the school, but it appears that we are paying that additional amount to the school by taking homes and property from senior citizens who really don't even have any kids in the school.
Maybe true.
Well, that's. I don't think he can answer that, Mr. Wingo can, or Ms. McRae. I only tell you is, I'm told by our tax commissioner in Fulton County, where you and I live, that if there's somebody who's a senior citizen, he works out a payment plan with them if they have a problem getting their taxes. That's what he has declared to me. Or how that works and all, I don't know. Mr. Fleming. We've had a off session, full day hearing on it. We had a hearing earlier during the session on 9/31. Question has been called. Any discussion on the motion to call the question? All in favor of the motion to call the question signify by saying aye. Aye. Opposed, like sign. The question is before us. Do we have any discussion regarding our motions as far as the Senate Bill 585? Move to pass. Do we have any amendments? Yes, sir, Mr. Winkle.
Yes, sir. You going to deal with that one?
What is your position on that, may I ask?
We can live with that. The way it reads, starting at G, line 23.
Okay.
The one you got circled here.
All right, I got you. I got it.
We don't have any objection to billing that in.
We have a motion to pass on the Senate Bill 585. Any amendments to the bill? Being no amendments? Yes, ma'am.
Opportunity, and even though this bill has a lot of things in one about notice and places where the facility could be, but is there the line, do you show the line where I can put in that give that shall and may language to the tax commission, and I would like to remove that language.
Now, I see you're saying now before the meeting, before the vote.
Yeah, you're just asking amendments.
All right.
Part of the bill, there has some good things in it, but part of the bill says that the tax commission may sell your taxes to a third party.
What we're talking about is the notice provision. Now, we're not in the issue on the sale of the properties, Ms. Thomas. We're only on the issue about right now under this bill dealing with the transfer of tax executions and the notice requirements as to that part of it. Let me read down. Look on page 3, line 22. Line 23 was in 60 days following the transferee shall notify the delinquent taxpayer of the transfer of the tax execution by first-class mail, and it includes what the notice is, and then if it comes back. So there is a shall there as opposed to may. Any other questions? No. Motion before us is a due pass on Senate Bill 585. Any further discussion? Question be called. All in favor of Senate Bill 585, due pass, signify by saying aye. Aye. Opposed, like sign.
No.
We'll have to have a show of, pardon me? By committee substitute, yes. Have to have a show of hands, please. All in favor of it, signify by raising your right hand. 1, 2, 3, 4, 5, 6. Opposed, like sign. 1, 2, 3, 5. The motion passes. Have due pass 585, committee substitute. We're going to move on now to the last bill for the morning session, which is Senate Bill 420, care of a grandchild. Senator Utterman. Is Senator Utterman present? Thank you.
Hello, Mr. Chairman.
Senator Utterman, so good to see you. Last bill we have this morning. Come on back. Would you present to us, please, your Senate Bill 420?
Thank you, Mr. Chairman and members of the committee. This is a bill that has gotten a lot of...
By the room. Go ahead, please. Excuse me.
A lot of publicity and recognition, and we're glad to have here with us today a lot of grandparents that are here supporting the bill. Senate Bill 420 is a bill that grants authority allowing grandparents and great-grandparents to take care and act on behalf of their grandchildren and their great-grandchildren. I didn't realize, but there are approximately 100,000 families in Georgia where grandchildren and great-grandchildren are living together with their grandparents. In July of this year, the Georgia Council on Aging met for their annual meeting, and they had over 300 members at their annual meeting. And this issue was the number one priority of the Council, Georgia Council on Aging. They voted, and this particular issue is the one that floated to the top. And the reason that it has and that it does continue is because grandparents and great-grandparents are having to deal with the problems related to school issues and health care issues where they actually don't have any rights to be able to admit a child into a school, to transfer a child into a school if they move into their home, and to adequately be able to take care of them. And one of their main concerns revolves around health care issues. If they are taking care of their grandchildren or great-grandchildren and the child becomes sick or has to go to the emergency room, do they actually have the authority and the ability to be able to make health care decisions in emergency-type situations and non-emergency type situations? So this bill went through the Senate Judiciary Committee, and initially the committee members had quite a few questions about it. I think they ended up with about 20 questions, and we put it into a subcommittee, and we worked out those questions, and that's why the bill has evolved into the number of pages that it is. Would you like for me to just go through it section by section?
Of it for us, please?
Okay. The first part, Section 2, this is Care of a Grandchild Act, and Section 2 just defines the problems that I just talked about. Article 4, Part 1 is Power of Attorney for the Care of a Minor Child Act. And under the definitions and the terminology, this is one of the things that the Senate Judiciary Committee worked so hard on, was explicitly describing and making sure that it was very tight language, that that there wasn't a whole lot of wiggle room to abuse the system. When it talks about school, we wanted to make sure that all children are covered, whether they're in a daycare program, pre-K, and on up into high school. The second section on serious illness on line 21, we wanted to make sure that if it is a mental illness, that a psychiatrist or a psychologist would have to be the one that would describe a mental condition, because we wanted to make sure that that was not abused. I'm just saying.
Can I ask a question, maybe to short a little bit? What is it that a party can do as far as going to the probate court and be appointed as a individual designated to take care of a child? What is that, Ms. Oliver?
A lot of school systems require
Mhm.
Yeah.
Is the school system opposing this bill?
No, they're not.
One of the reasons this is a good bill is that it doesn't require grandparents to go through that legal procedure.
Right.
Because the court doesn't need to be involved. But that happens in the Camp County District.
Happens in Fulton too. I know I've had situations that come up.
I've got a couple questions.
Yes, ma'am. We're gonna let you want a particular point, or you want to wait until she gets through presenting? Why don't we go through and let you briefly present it? For
Okay.
us, if you want.
Okay.
Go on.
Okay.
Break your continuity. I just
I'll
can't
try to be brief. It talks about what constitutes a terminal illness, because we didn't want a parent, just to say, well, I'm sick and I can't take care of this kid anymore. We wanted to be explicit about it. The other thing was the Senate Judiciary wanted to make sure that hardship was defined, and these parameters that we set up: death, serious illness, terminal illness, or incarceration of a parent, because incarceration is one of the main reasons. The physical or mental health condition of the parent. And Section C on page 3 talks about a natural disaster. That issue got brought up with Hurricane Katrina and people moving into our state. And lastly, Senator Harp wanted to make sure that those folks that are on active military duty, that they could facilitate and use this and make sure that they were covered. One of the questions was, we wanted to make sure that someone was not trying to flee some type of investigation by DHR, and DHR wanted the clause on there about subverting an investigation, and that's on line 7. The other question was brought up: how do you notify the non-custodial parent, and who has the rights of the child, and getting involved in that? And line 16 talks about certified mail and this being notarized. One of the issues that got brought up frequently was talking about, what if you have a child that's like a star athlete, and you wanted to use the system and just move a real good athlete from one school system into another school system. So we explicitly stated in there, talking about a sports clause and having actually this part on line 25 talks about enrolling the kid in extracurricular activities and obtain medical, dental. The sports clause is on another page, and making sure that the child is taken care of by providing food, lodging, housing, and recreation. That sports clause that I was talking about is on page 4, and that's section O, where it talks about the child violation of this section shall be punishable, so that folks wouldn't be able to do that. And right up above that, M is a liability clause that that any person who is actually participating with this and using the power of attorney, that the liability will be released. And Section P is a vacation clause. A lot of the senators had questions about, well, what happens when I go to Europe and I leave a note saying I'm leaving my kids with my mother and father, and they're allowed to take care of it. So this is not to replace a temporary written grant, and that was specifically put in there. Moving on, the next section actually goes in to describe the form that will be used, and Representative Crawford, I think, has some valid questions, and talking about the termination. He's going to bring up some questions, and I think his points are absolutely valid, the questions that he had. But on line 22 and 23, a court can take away the powers of the agent if it finds that the agent is not acting properly. So there is a termination clause in here. If you do have the power of attorney enacted, and there are reasons, the court can terminate the power of attorney. The next few pages, page 5, 6, and 7, are the actual form that can be used, and the signature page. and it has to be notarized. And then the last part of the bill goes into section 19-9-142 on line 9 of page 8, and this talks about setting up a pilot program. In the state of Georgia, we already have programs that are being used that are actually doing this and teaching grandparents and letting them know how to take care of their grandchildren and what their rights are, and using resources, using the school system. And we specifically stated that setting up a new program in Georgia, that they would the pilot program would be a part of the existing programs, and they're located throughout the state of Georgia: Clayton County, Rome, Athens, Augusta, and Atlanta. And there are some people here today that are actual caseworkers and grandparents that are in those programs, and they're probably going to ask to speak, and I'll let them tell you about that. It did set up parameters about what the new pilot program would be, and there's no more than 1,300 families to be enrolled. It'll be a part of the Division of Aging Services. Since the time that I wrote the bill and started working on it this summer, there's been a lot of issues and questions raised about it, and I have been working with DHR, with the Commissioner, B.J. Walker, and also working with Abel Ortiz with the Community Health Department, in seeing what services and what availability of new services that the state could offer to these grandparents. And as you know, we have a new commissioner. Commissioner Walker's doing a great job with DHR, and she is committed to helping these grandparents. And my question to both of the departments was, well, if these resources were out there, why haven't we been facilitating them before? And other states, there's 40 other states who already have these types of programs, and why haven't we done it? And the commissioner has been very proactive, and she has set up a focus type group. I'm not sure if anyone is here from DHR, but they can explain it. But I do have a letter here stating the different things that they're doing to work and to draw down federal money and to use federal money, to use TANF money, to work with these grandparents, trying to get them enrolled in a foster care type program. The pilot program sets up a 80% subsidy for those who meet federal poverty guidelines, and she is willing to work with them to actually get them up to 100% of the foster care rate, so that we can keep families together. I do have a copy of this if you'd like to see this. And in this year's budget, we've been working on, I think there's $1.3 million allocated for the pilot program, and I've been talking with Abel Ortiz and the commissioner and trying to work out what exactly this money is going to go for. If we're going to be using the federal TANF monies, what would this additional be needed for? So we're still working on that part of the budget.
Thank you, ma'am. Mr. Fleming.
Mm-hmm. Bill to us today. I know Jeff May in the House had something similar dealing with the grandparents, and unfortunately in our society today, we have a lot of grandparents taking care of children, but it's a reality. So I thank you for working on this. There's some smart lawyers on this committee like Ms. Oliver and Mr. Hatfield that may have some legal questions about it, but I want to focus on the last part dealing with the pilot program. Like I said, the first part, I think the concept is great. The last part dealing with the pilot program, I notice in here that specifically there's laid out some in section E on page 8 at the bottom, some groups in various parts of the state that apparently already work with these issues, these private groups. And my question to you is, how important is this last portion of the bill to you, which kind of sets up a new government program, albeit a pilot program, versus the rest of the bill? I mean, would you...
Well, I asked that same question, and that's why I brought it up, because when I talked to the commissioners about it, if it's so important and it's been such an issue, then why haven't they tried to facilitate using the TANF dollars and helping these people? And it's just that the answer that I've gotten that I felt comfortable with was they just haven't gotten around to it, and that they're willing to start doing it now, and that's why I brought the letter showing that I have been working with them. But it is important to me, and it is important to the Council on Aging that this pilot program be in it.
The portion there of the pilot program, what I thought I heard you say, and correct me if I'm wrong, is that the people in the state agencies that already exist that could do this have now told you that they're moving in this direction, not doing some of the things already. So it brings back to my point: do we really need to set up that pilot program if there's already state agencies out there that are participating in doing this? And like I said, I'm not against the idea. I'm just saying, are we duplicating something that may already be going on or could be going on by people whose attention you've gotten now?
I really don't think it's a duplication. I think it's just putting into law what we're doing and basically holding the departments accountable and continuing what they're doing. And I think that accountability, I have more assurances if this were included in law.
Okay. Thank you.
Yeah, what we're going to do, let me just interrupt for a second. We're going to be running short time-wise, and what I anticipate we'll do is we'll go to 1 o'clock. Do your time presentation from the committee and take a 30-minute break, and we may then re-adjourn over at the LOB where we're going to be for the child support, which is going to be in room 415. Okay. Let's go ahead then. I think you were next, Mr. Hatfield. No, sir. We'll have to get through with it. We got through in time, but I think we're going to be... I'm going to go to 1 o'clock at this point. I don't know what's going to happen by 1 o'clock.
Thank you, Mr. Chairman. Senator, a couple of questions I have. This bill would provide for this procedure to take place without any court approval, is that correct?
Yes.
If you have parents who have divorced and one parent has custody, the other one has visitation rights, and a parent, under current law, if a custodial parent should become physically or mentally disabled, unable to care for a child, then that would normally be a ground that could be considered by a court in determining a change of custody, wouldn't it? Okay. There's nothing in this bill that would indicate that the granting of this power of attorney to a grandparent was not something that could be considered by the court in a change of custody action.
That's my understanding.
Okay. So in other words, if a power of attorney was granted to a grandparent, then the physical or mental illness of the custodial parent would really no longer be an issue with regard to a change of circumstances. Is that true?
I think that's true.
Okay. So essentially, the grandparent, as a result of this power of attorney, is going to be getting all the incidents of having custody of a child. Is that also true? And would likely be allowed to retain custody of a child over a natural parent, a natural non-custodial parent.
I think the way that we left it was that the judge would have it at his discretion, was my understanding.
Okay. Are you familiar with the grandparent visitation statute that was passed by the General Assembly several years ago and held unconstitutional by the Georgia Supreme Court? Has there been any attempt to reconcile this or to look at this statute in terms of that decision and whether or not this statute would be constitutional?
No, the Judiciary did not do that. No, sir.
Okay. That's all.
Ms. Oliver.
I'm for this. I want to make sure that the grandparent who has the power of attorney doesn't, I think I'm clear about this, but I want to make sure you agree, doesn't acquire any financial power of attorney over their children's money. Does the grandparent automatically start getting, can petition to start getting the Social Security money, and the child support can start coming, but this doesn't address any of that.
I thought that it did.
I don't think it does.
Okay.
But is it your intent?
Yes, that the money would follow the child, yes. Mm-hmm.
I think that on page 3, paragraph B, it says the circumstance where both parents have legal custody. That means that they're still married.
Right. Mm-hmm.
And in paragraph E, if only one parent has legal custody, that means that there's either a divorce order or there's an illegitimate child out there who's not been declared a legal child.
Right.
And the father of the illegitimate child doesn't get notice under this. And probably, I don't know where he should, but that's...
It's not an issue.
It's not my issue. But the father who is the non-custodial father definitely should get notice, and I have an amendment prepared that says if the grandparent gets the power of attorney, the grandparent has to comply with any order of visitation. And I can see a scenario where the non-custodial issue's father doesn't really object to the grandparent taking legal custody, but is going to want his visitation. Now, if the non-custodial parent objects, here's what I don't know the answer to. Either parent can revoke the power of attorney. Can the non-custodial father revoke the custodial parent's power of attorney to the grandparent, or can only a judge revoke the custodial parent's power of attorney, and what should the policy do? That's my question.
Treacherous ground. I agree with you.
What should the policy do if this bill is silent on it, which I think it is?
Mr. Chairman, can I comment on that?
Yes, sir, Mr. Hatfield.
I certainly think, Representative Oliver, that a grandparent, I support the idea of a procedure to allow grandparents to have a power of attorney. The problem I've got is that the way that this bill is written, I think it would allow grandparents to have a preference over a natural parent, and that's what I've got a major problem with.
I don't think that does. I don't think that changes the law. I think if the non-custodial, this is a non-custodial father objects, he trumps the power of attorney. The only question I've got in my mind is, if he objects, does he trump it by simply revoking it, or does he have to go to court?
May I insert my thought here? That's what E does. E is to give the non-custodial parent notice of what the custodial parent is doing with the granting of a power of attorney to a third-party parent, grandparent, or great-grandparent. Now, once he receives notice, it's up to him to either say, I refuse to let you do this, and I'm going to stop you from doing it.
But can he stop him by revocation, or does he have to go to court?
I think he may have.
I think he can stop it by revocation, but we have the power to decide that.
Yeah.
Mr. Chairman, if I may, just further on that point, my concern is also when you talk about modification actions, normally if you had a parent who's a custodial parent and they are mentally unfit to care for a child, that would be a solid ground to ask for change of custody. Now, but it has to be a present unfitness, and the question I've got is, if you put the child into a power of attorney relationship with a grandparent, are you taking away the non-custodial parent's grounds to seek a change of custody?
I am not going to worry about the non-custodial parent's interest, except, I'm not going to presume that the non-custodial parent wants to trump the power of attorney. My policy consideration is the power of attorney should be good until, and here's the question, the non-custodial parent either revokes it or goes to court. I'm going to give it preference, presumptive preference, and then I want us to talk about and decide whether it's a court or a signature. I'm not concerned with your concern.
Naturally. Ms. Stevenson, you're next.
Thank you, Mr. Chair. I want to start back. I'm going to end up with some of those substantive issues you all raised, but I want to start off by addressing the first part that my colleague, Representative Fleming, raised, because I think those are very important, and thank you for bringing this bill. First of all, is my understanding that the pilot program is so important twofold. Number one, the commissioner has undertaken a great job in, number one, reducing congregate living facilities in the state of Georgia. Number two, decreasing some of the bureaucracy around foster care. In doing so, encouraging families to keep children within the families, and that this pilot program addresses some of the stipends. I believe that's why some of the language looks at the average cost of foster care, to do a pilot program to determine if it decreases the amount of monies that taxpayers, and still give even a greater quality of life for the grandchildren that the grandparents are raising. So this is one to look at decreasing the monies that have been spent with the bureaucracy around foster care. In respect to the, yes, let grandparents, so to give some incentive. The incentive now is like we have an incentive to put people in hospitals. We have an incentive to go to foster care versus the incentive to allow children to stay within their families if they can. So that this pilot is to do it, and I believe it was very conservative to say no more than 1,300, and then you report back to this General Assembly next session, and you tell us if it worked or not. But if we can make that happen, that is best for our children, and that's why I believe that part is important. Well, yeah.
Is everybody here? I want to ask.
That's okay. I'm used to doing that, but I'm going to finish this other part. I know what happened to it.
Pardon me?
The monies were cut.
Okay, we'll have somebody speak, I think, from DHR on this program. Let's move on from that point so we can get some.
I have a second part to my question, Mr. Chair. Now, the monies were cut for that program, and this is a way of looking at it different. We have a new DFACS person. We have someone that's looking at a system in the best interest of the child and within the fiscal budget that we have to operate, and I think those are the best of both worlds. As it relates to the whether or not the non-custodial, I believe under this bill, the non-custodial parent has to take an affirmative action in court that it does not trump. Now, we may want it to, but under this bill, right, I think it's open. But the way it's worded, I don't believe a non-custodial parent could revoke this power. But generally, this bill addresses those children that are in households where you have legal custody, and the non-custodial parent is probably not in the picture, because if it were so, there would be the formal guardianship. So whatever language, because I believe it is silent if we want to improve on it, but for the most part it gives those grandparents, it's near and dear to me, this bill, it gives those grandparents the opportunity not to go through all the judicial maneuvers that it takes when they already have physical custody of the children anyway.
Good point. Any further discussion regarding the part? Yes, sir, Mr. Thomas.
First way is to use the capacity of condition, and one of the conditions here is the lack of mental condition. That's hard for me to reconcile. If they do not have mental capacity, how they could exercise the power of attorney. And I guess the second thing, I'm not quite as, I consider this a light solution to something that's very, very important. I'm not leaning toward it, but it might be the other. Let's just say it was an estranged couple by divorce, and I disagree with Mary Mark. I think that person should have a form to complain, the non-custodial parent, and maybe the grandparent of the husband say that might be a better. I mean, there's just no form here, which I guess the lawyer side of me, but Bob, I like the intent, and I also know it's very much reality, and I'd like to thank you for bringing it, but it's the lack of form that concerns me, and maybe the lack of capacity of the parent to execute this.
Let me address that last point. If you recall, a couple of years ago, we enacted a standby guardianship law, which I think was intended and does, in fact, pull in some of what we're trying to do here, where you have a parent who is either becoming incapacitated or is incapacitated for health reasons, including mental reasons, and they were able to place the custody or control of that child with someone, usually hopefully a family member, but didn't specify, just someone. And I don't know if we're doing anything to disturb that or embellish it, or what may be the case.
It was my understanding that we weren't doing anything.
Yeah. I mean, it did answer this thing about the question raised by Mr. Tumlin regarding, on page 2, this definition of serious illness as being a way that a parent can do something with a child that they're caring for, and there's no one else as far as immediate family to do it. Go ahead, excuse me. Any other thoughts or questions at this point? Mrs. Stevenson.
Who's going to decide that? Nobody touches.
Well,
that's my problem.
That's
right. The parent can determine, and someone else can challenge it, just like you would if you were mentally incapacitated.
I bet.
Have to be adjudicated by the court.
Let's ask 2 more questions, then we'll take the break. Ms. Oliver, I think you had your hand up first. Go ahead, Mr. Bruce.
So based on the time, I'm assuming we're not going to vote on this until
I don't think so. No, sir.
Okay, but they haven't presented the bill.
1:30. We're going to meet back at 1:30 across in 415 of the Coverdale office building. All right. So we'll be right there with you.
Okay.
Ms. Oliver.
I was just saying, I'm not going to worry about Mr. Tumlin's incapacity issue, because that happens in the existing probate court proceedings where a parent is transferring custody for the school residence issue, which is a big deal that I've always been on. I'm only, and I'm really interested in think about whether or not the non-custodial parent can vote by signature, and whether we're going to require a non-custodial parent to go to
I think we need to address that perhaps with some language in here we might get to in the break time. If no further questions of the presenter, Senator Utterman, I'm going to let you stand aside. We have a couple other people who want to speak here. I've got Dorothy Carrillo with Georgia State. Come forward, please, Ms. Carrillo. Yes, ma'am.
I know everybody must be hungry. I am. But anyway, I'm Dr. Dorothy Carrillo, and I'm representing the National Association of Social Workers. I'm also the Associate Director of Project Healthy Grandparents at Georgia State University. And I ask your support for the Care of a Grandchild Act. And I sincerely hope that the debate and questions that have been raised today can lead to a compromise so that this bill can get passed. It's already been noted that we have almost 100,000 families in Georgia made up of grandparents raising grandchildren. And while the first part of the bill addresses the power of attorney issue, it is the second part of this bill, the Grandparents Caregiver Subsidy Act, that addresses the most critical financial needs of these families through this pilot program. And it will provide much-needed financial relief to families where their income is less than 200% of the federal poverty level. This is really the heart of the bill. At Project Healthy Grandparents, we've worked with over 500 grandparent-headed families, and that includes 1,150 grandchildren. What we find is that 60% of these families have incomes at or below the poverty level, and 40% of these families are in very dire financial straits. If this bill is enacted with subsidy, it channels much-needed financial assistance to the very poorest of these grandparents who are trying to raise their grandchildren. Thank you.
Thank you, Doctor. Appreciate you coming in and being with us today. We have Carl Johnson with the Georgia Association for Marriage and Family Therapy. Dr. Johnson, good to see you again.
Good to see you. My name is Carl Johnson. I'm the Executive Director of the Georgia Association for Marriage and Family Therapy. I will be very brief because it's been a long morning. Our Board of Directors reviewed this bill and voted unanimously to support it. What struck me was our board consists of 25 senior family therapists from around the state. What struck me was how many of the members of our board of directors had encountered in their practice a situation where grandparents were effectively raising their grandchildren by default. And that's what really we're talking about here. It's not transferring custody. It's grandparents who are raising these children effectively by default. And then they discover that then they run into problems with getting medical care or getting the kid in school, something of that sort. We understand that there's a court proceeding you could go through, but our experience is that more often than not, you have to have adequate savvy and adequate finances to go through that court proceeding. These are more often than not, the families who don't have the savvy and don't have the financial resources to even realize they needed to go through the court proceeding. They're raising their grandchildren by default, and then they run into problems. Correct. And we see. I was surprised again at how many of our members of our board had encountered that in their practice, and so we encourage you to support this bill. One of the things we would commit to, we thought it was going to be very important somehow to get the word out that this authority would be available if this bill were to pass, and we would certainly commit to educating our members about the existence of this authority so they could then work with families that they encounter to execute it properly.
Thank you, Dr. Johnson. We're going to recess now for lunch, and we will re-adjourn over in the room 415 of the Coverdale office building at 1:30.